Good evening, chat. Hello. Hope you guys are doing well. Well, it's not Thanksgiving yet, but happy night before Thanksgiving. I know we're to the busiest bar day of the year. Hopefully, you guys have made your journeys where you're going, met your family, met your friends. Yeah, I hope you guys had a good day today. Hope everybody's had safe travels. If not, and you're still doing it, uh, good. Be safe. Be safe, guys. Please be safe. In the meantime, I do want to welcome everybody here. My name is Sean, also known as Potentially Criminal. I am a defense attorney in the Cleveland, Ohio area, and tonight we're going to cover the Illinois assault weapons ban, turning over the PICA. This is not an anti-Pokemon Act. Getting the Pikachu reference there. No, the Protect Illinois Communities Act, which was basically an assault weapons ban and a magazine ban that got passed in the state of Illinois, going back. And we are going to look at the district court in Southern District of Illinois that overturned it. Now, before I get too far, when I was making give people a minute to get in here. I when I was looking at it, I had to make the Illinois flag for the thumbnail here, and Illinois has a very interesting, very interesting like their flag has got. I couldn't help but notice this. So this is the Illinois flag, and when you look at the eagle, it very much looks like that eagle guy from the Muppets. Because look, it doesn't look like a normal eagle. It kind of looks drawn on. Like it looks like it's drawn, like a little poorly drawn. It's got like the poorly drawn like talons for feet. So I think it's a little interesting the way it's drawn on there. But I understand we all can't be like Ohio where we have a badass looking flag. Yeah, Sam the Eagle. There we go. Sam the Eagle. Sam the Eagle. No step on eagle. Yes. Mexico has one like that. Yeah, I know they do, but we're not Mexico has its own issues. Sharmuta says, look at Eagle Man Insurance in Chicago. What the hell is that? Okay, hold on here. Eagle Man the Eagle Man Insurance Agency. What the heck is this? Oh my god, this is oh my god, this is a real thing. Holy cow. Okay, apparently this is the name of a insurance company in Chicago here. We're gonna can you guys see this at all? Hold on here. Can you guys see what we're looking? Yeah, you guys can see what we're looking at here. All right. We're gonna watch this real quick, then we'll get into the decision. Okay, here we go.
What's that?
Do you have insurance on this car?
No.
It must be Eagle Man.
I've got something for you.
Oh, look at those low rates.
Eagle guarantees the lowest auto.
So it's like a furry. You guys have furries in Chicago. No, chat, no, that's a furry. That is a furry. Maybe you know what, Illinois? I changed my mind, Illinois. Maybe you guys don't deserve to have weapons. If you guys have that going, no, done. You have a furry like that, and you're like that's considered like nostalgic for you, and like, oh, that's just we're kooky Illinoisans. Like, no, you technically you don't get to have furries like that. Praise them and own guns. Sorry. That's the way it goes. Never mind. I'm calling the judge. I'm gonna come like, judge. No, you guys, listen. It went too far. You guys like furries up there. You gotta change the ruling. Amend it. No! No! I'll have to call the 7th Circuit and tell them to stop this. We also have the Screaming Mattress Man. Oh, it was the 90s. It was a different time. Yeah, well, yeah. I'm considering all these people dropping furry terms. I know, that's the other thing. We just sussed a lot of you out, chat. That was a plot. That was a trick and a trap. We need to play the trap card. Yes, male eagles can lay. Hey, remember, men can have babies. We learned that in the past couple of years. Oh, sussy chat. Sussy chat. All right. Let's get to the assault weapons ban issue. So, yes, Illinois passed the PICA Act, and we're going to get into it. This is 168 pages. It took me a while to get through it because this wasn't the only thing I had to do. I actually had some impending issues I had to take care of, like real life stuff that had to get done. But yes, one of 168, chat. This thing is a beast. A beast. So this is in the Southern District of Illinois, as you may know it. You may know it as the state of Illinois, but I think the French Illinois sounds better. To quote the great Strong Bad. But yes, there are multiple people here. There's 4 defendants. I mean, there's 4 plaintiffs here. It's part of a class suit, and it involves different organizations here going forward. Now, it's very interesting how it starts off. When it starts off, you just love how this works. You know, why are there lifeboats on ocean liners? Why do we spend thousands equipping our vehicles with airbags? Why do we wear seatbelts and place our babies in car seats? Why do we build storm shelters under our homes? Now, for those of you who are not American, a storm shelter is a tornado shelter. Illinois is it's kind of on the edge of Tornado Alley. Tornadoes are very common there. Even into Ohio, they're somewhat common. Not as bad as like in the middle, like where all the storm chasing happens, but it's still, here in Ohio, like everybody knows, you go to the interior room, you go to a bathroom, hop in the tub, or you get down in the basement. Yes, you prepare for storms. Why do we install GCI, ground fault interrupter outlets by sinks and bathtubs? And I don't know if you have these in Europe, but those are they're ground fault interrupters meant to protect you from getting electrocuted. It's a specific type of outlet, and that's actually a building code thing. Why do we get painful inoculations? Well, I mean, because sometimes we're forced to do that. And why do we voluntarily undergo sickening chemotherapy? And why do we protect ourselves with firearms? Pretty based starting off thing. Stacy says they don't put plugs in bathrooms in Europe. Well, that's their fault. Yes, and now there's even requiring arc fault breakers. Yep. Sarah Brown says, okay, this is fair. If we're printing our own currency, why do we pay taxes as long as we're asking these types of questions? Okay, that's a fair one. Yes, why do we have to pay taxes if all we can do is print money? I don't really have an answer for you there, so. I do not have an answer, but you win. All right, so, and this is just the beginning. But once again, this is a judge who is laying the smackdown. Now, we do run into some issues. We're going to get to the end of this, guys. This is not a complete victory, and it leaves me with a lot more questions of where we're at. So, there is celebration, but there's a lot of concern here as well. He says, in life we face many perils. Some are in natural weather phenomenon. Some are biological, such as virus, disease, or malignant cells. Some are associated with important products like electricity, natural gas, matches, automobiles, and pain-relieving medications. Too often, the perils we face are forced upon us by other people. By people who are negligent, reckless, insane, impaired, or evil. Sometimes it's the proverbial lone wolf. Sometimes it's the whole wolf pack. Truly, life comes at you quickly. Yes, life does come at you fast, chat. Very fast. So it's something to think about. It's something to think about. Life comes at you fast. You know, and who comes to our aid in times of peril? Yes, sometimes it is the police or first responders. Although, to be fair, this is a big argument. You are your own first responder. You are the first responder. You're the first person responding to the issue. It's you. You are the first responder. Someone breaks in your house. Guess who's responding first? You. So I hate this argument. How they use it. Other times it's healthcare professionals, and sometimes it's family, friends or neighbors. Sometimes it's no one. No one is coming to save you. You'll have to save yourself. You know, no one's coming to save you. Perform self-rescue. And I think that's always important. Assume you're on your own. So from here, he gets a little more philosophical, but I think the bigger thing for us is to move on to the Protecting Illinois Communities Act. And he just explains the beginnings of it. So the PICA Act criminalizes knowing possession of hundreds of previously lawful weapons, including rifles, handguns, and shotguns. It also bans various attachments, accessories, configurations, so-called large capacity magazines. I mean, they're not that large. They're pretty standard. It also created a firearm registration program requiring registry of arms possessed prior to January 1st, the date after which PICA would be enforced. Now, what happened? Why did PICA get put in place? So this is going back to 2022 in Highland Park, Illinois, outside of Chicago. The guy went to the 4th of July parade up on a roof and started shooting people sitting around in the parade. So there we go. And then Illinois started banning things. Now, going through all of this and the procedural background, this is actually another important step here. We're going to get to the background of all of this. So the PICA Act was signed in response to the July 4th, 2022 shooting. So what happened from there? Well, here, there are other cases. So here are all the cases that are before it right now. This matter is before the court for a final adjudication on the merits of the equitable claims brought forth by the plaintiffs in Barnett v. Raoul, Harrell v. Raoul, not Uncle Paul, chat, different Harrell, Langley v. Kelly, and the Federal Firearms Licensees of Illinois versus Pritzker. And that means Governor Pritzker. So these cases have been consolidated, and they're asking that PICA be declared unconstitutional under the 2nd and 14th Amendments. So there are also preliminary injunctions to enjoin the enforcement of PICA in each of the 4 cases. These were granted already in April of 2023. Now, the 7th Circuit vacated the preliminary injunction in November of 2023. You see this case, Beavis or Bevis versus City of Naperville. I still think, damn it, Beavis. Damn it, Beavis. And then you saw a second motion for a preliminary injunction was filed in November, which this court denied on December 22nd. That said, once the 7th Circuit said they weren't going to grant it, I didn't expect this court, they're not. This court is doing it the right way. I'm being told no, so I'm not causing problems. Now, from there, the various plaintiffs in Bevis, they filed petitions for a rehearing by the same panel and for a rehearing en banc. Now, in the federal circuit courts, you can ask for a rehearing. You're not entitled to it. You can ask for an en banc hearing, meaning the entire 7th Circuit, so it's no longer a 3-judge panel, but the entire circuit sits down. We talked about this before. Those happen, but it's not always common. Those were denied. So they then went to and they filed a writ of application for writ of injunction with the Supreme Court. And Justice Amy Coney Barrett was the judge writing circuit for the 7th Circuit. And she referred the application to the full Supreme Court, which denied it back in December. And I think we talked about this. So they were denied. And then they turned around and sought writs of certiorari before the Supreme Court. All of these petitions were also denied on July 2nd. So there we go. That's kind of, there've been a lot of losses. A lot of L's been taken here. So here we go. Now, there are other things here. They note that this court notes the government's objections to various evidence and expert testimony offered by the plaintiffs are addressed via separate order. There's one additional motion pending. The government submitted a motion for partial summary judgment on the Langley plaintiffs. And then from September 16th to September 19th, this court held a bench trial during which the plaintiffs and the consolidated defendants in this matter called witnesses and presented evidence. Various issues were presented to the court via post-trial proposed findings of fact and conclusions of law, submitted on October 21st. Now, that's important, chat. That's important. So, what is a finding of fact and a conclusion of law? So, you present evidence, and then you present to the court what you actually, not only you're saying, judge, find in our favor, but you want the court to find in your favor, and you want them to find these facts. You want the court to say, here are the important facts. I agree these are relevant. Here's the applicable case law. You're basically giving the court a script and saying, judge, take our script. The other side's going to say, no, read our script. Now, the court may accept one or the other, but the court can also pick and choose. It can reject both of them. But this is a way you can present to the court what you want to do and what you want to happen. Travion Washington says, I prefer an end bank hearing. Well, don't bank them up. You got to spend them. There's no, they're inflationary in value. All right. So that's what findings of fact and conclusions of law are. You're basically telling the judge exactly what you want them to do. And that's a very common thing in a civil setting to seek. So the court begins its analysis. And we're going to skip ahead here. We're going to blow through the history of this because this judge does a very good job of laying out the history here. So for the Second Amendment, it really started back in 2008. Guys, really, it's only been 16 years. It's only been 16 years, and it's important to realize that. We have not had the time out there. So we have District of Columbia versus Heller. And if you guys remember, for Heller, that was about Dick Heller. He was a retired cop. And he wasn't allowed to keep a handgun in his home under DC law. And he wasn't allowed, it wasn't that he wasn't allowed to keep, and I didn't get to finish that. He wasn't allowed to keep it in a state that was readily usable. It had to be disassembled and made not readily usable. Well, in Heller, the Supreme Court ruled there seems to be us no doubt on the basis of both text and history. The Second Amendment conferred an individual right to keep and bear arms. Now, if you guys remember, 2008 was a very different time on the Supreme Court. And why is that important? Because, well, that shaped a lot of what we're looking at here. And the judges on the court at that point, there's people that don't exist anymore. John Paul Stevens, Antonin Scalia, Anthony Kennedy, Ruth Bader Ginsburg, and Stephen Breyer, David Souter. I mean, of the judges that were on the Supreme Court at that time, there was Chief Justice Roberts, Clarence Thomas, and Samuel Alito. I mean, think about that. We are dealing with Heller. We are dealing with going back 16 years. Think about who's gone. Thomas, Alito, and Roberts. That's it. Everybody else has been replaced. It's insane when you think about it. It's crazy. Time flies. Ginsburg died. Like, think about it, going all the way there. Well, that's important to remember. Because when we talk about Heller real quick, Heller was a difficult piece. Because the majority was Scalia, Roberts, Kennedy, Thomas, and Alito. And Kennedy was the flip-flop. Kennedy was the fifth vote. It was a 5-4 decision. You had Stevens, Souter, Ginsburg, and Breyer all on the other side. And it's funny, all 4 of those justices are gone. But it was Anthony Kennedy that was the critical vote, and it's probably there's part of the reason why some of Heller's watered down, and we're going to get to one of the other reasons why I think Heller appears to be watered down. Now, going on further, the Heller court held the prefatory clause, a well-regulated militia being necessary to the security of a free state, announces the purpose for which the right was codified to prevent elimination of the militia. Yet, it does not suggest that preserving the militia was the only reason Americans valued the right. Most undoubtedly, though, it even more important for self-defense and hunting. And Heller did point out the right's not unlimited, just like the First Amendment's right of free speech was not. And they said that they don't read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation, just as we don't read the First Amendment to protect the rights of citizens to speak for any purpose. Yes, but I think we would all agree the amount of things you can't say and the limitations on speech are very small, and any restriction on it is very suspiciously viewed compared to, laws against owning and possessing firearms. Now, there are other cases that went around. They talk about Williams here, that there were imposing qualifications on the sale of arms or restricting dangerous weapons are permissible, restricting permission by felons. Then there's U.S. v. Miller. Once again, Miller is always interesting because Miller was dead by the time his case came about. And more importantly, the issues about whether arms were in military use and were in common use at the time. Of all the justices on the Supreme Court at that time, I remember looking back, there only one of them had any military service, and his service was as a judge advocate general, as an attorney in World War I. So he didn't go to the front, and they were using all kinds of things in World War I to fight. So it was Miller. Miller is a problematic case, and the thing is, it's never going to go away. You're never going to see it get overturned. But as we get to it, there is an issue here, and this is one of them. And it says out of Heller, they said, moreover, while it may be objected that if weapons that are most useful in military service, M16s, rifles, and the like may be banned, then the Second Amendment right is completely detached from the prefatory clause. Now, there were some limitations in Heller, and a lot of that was because Anthony Kennedy, they needed his vote. So they did what was necessary. Jarda says, weird the stuff that's filtered here. I have no filters in place. Any filter is imposed by YouTube. I don't filter or limit things at all. So if there's anything being filtered, I don't filter it. I have no filters in place. But chat, and getting back to Heller, there were issues with Heller because remember, yet again, Anthony Kennedy, he was the fifth vote. And that's a problem. So you got to get him on your side. So there were some limits to what you could do here. I'm sure Clarence Thomas wanted to do Bruin right away, but he couldn't. He could not. There were limitations there. Miller was well beyond problematic, yes. Maddie says Miller wasn't even present for the case. Well, Miller was dead, so that's an issue. Abel, I see your question. We'll get to that in a minute. So Kennedy was part of the reason why it was watered down, but also remember at the end of the day, and I've said this before, the idea you're going to get the Supreme Court to say you can own a machine gun is probably not going to happen ever. Like I said, you would need 9 Clarence Thomases on the Supreme Court to make that happen. And that ain't ever happening. So, and we're going to see that throughout this. But anyways, they get on the common use here and they say, thus common use determination overrides whether or not the weapon in question was restricted in the past. What matters is that the weapon cannot be considered highly unusual in society at large. And yeah, the AR-15 is not unusual at all. Moving on from there, the court talks about the McDonald versus City of Chicago. And that incorporated the 14th Amendment due process clause into the Second Amendment, making it applicable to the states in addition to the federal government. So remember, Heller was about the District of Columbia. And every other amendment, the First Amendment was incorporated. You know, the 4th, 5th, 6th Amendments, the 7th Amendment, the 8th Amendment was incorporated to the states and applied to the states. But the Second Amendment, well, technically we had done that yet, is what states tried to do and what the city of Chicago tried to do. So the Supreme Court had to come back and say, listen, chuckleheads, it is. It is part of it. But in McDonald, they went further and said self-defense is a basic right recognized by many legal systems from ancient times to the present day. It is. And the right to keep and bear arms is among those fundamental rights to our system of ordered liberty. And they did say further, they said, we reject the suggestion the right was only valued as a means of preserving the militias. And they say, on the contrary, and they're saying this is the court in the Heller court, we stress the right was also valued because the possession of firearms was thought to be essential for self-defense. As we put it, was the central component of the right itself. And yes, going through, and they talk about during the ratification debates, the Federalists and Anti-Federalists, the right to keep and bear arms is critical. And the funny thing was, when you talk to the Federalist arguments was, there's enough check. The government is too limited in power, and no government would ever do that. And the Anti-Federalists said, you can't trust government. So eventually, what was the compromise? The Bill of Rights. But even the Federalists were in favor of the right to keep and bear arms. They just didn't think it had to be included. And the Federalists responded saying the right was adequately protected by the Constitution's assignment of limited powers to the federal government. They said the government can't do it. Well, it's nice if people would know about that today. But going forward from there, 4 states had adopted the Second Amendment analogs before ratification, and 9 more states, including the great state of Ohio, adopted in their state constitutional provisions protecting and enshrining the individual right to keep and bear arms between 1789 and 1820. Yep. So they keep going here, and they talk about through the 1850s, things that kind of waned down. And this is very much written, I will say, Chad, at times like a law review article. So, I mean, it's 168 pages. This is very in-depth. But they talk about the issue of in bloody Kansas with the Free Soilers, and there were attempts to disarm them. And, Senator Sumner, one of the leading advocates of the 14th Amendment, said, never was the rifle more needed in just self-defense than now in Kansas. And if you guys don't understand, Kansas was insane. Bleeding Kansas, when you read about what was going on in Kansas, it was like something out of the Balkans. It was like the Bosnians and the Serbs going at it. You had people like John Brown on one side, and you had Confederate raiding parties and flying columns on the other side, just going back and forth, just butchering each other. It was rough out there. It was rough out there in Kansas. And they go into after the Civil War. Throughout the South, armed parties consisting of ex-Confederate soldiers serving as in state militias forcibly disarmed newly freed slaves. That was a common thing. And this is a thing we still see today as a result of, and Bulb says read all of it. We are not reading all of this line by line. We are not reading all of this. This will kill us. Oh. Now, what is the problem here? And this is something we still see today with laws like, for example, in Florida, where you cannot openly carry firearms. Many states in the South still had issues with, for quite a while, of openly carrying firearms, or you see in places like North Carolina where you have to get a permit to possess pistols. I believe that there's other places where this has happened. Other states have fairly restricted things. Texas had a restriction on open carrying of firearms for quite a while too. It wasn't because in Texas you could say, "Oh, it was a deal with the Cowboys." Nope. It was a anti-black measure. And it was a Reconstruction issue. States were struggling with issues about making sure black people in the South couldn't own firearms, but also some states that did want to protect blacks were trying to prevent militias and mobs from being formed and posses from being formed that would go around to chase and harass and murder black people. So they were preventing people from openly bearing arms and congregating groups with guns. Yeah, Rod is saying it's a purchase permit in North Carolina. Yeah. There's a reason why that is an issue. It's because it's meant to a purchase permit. Well, you need permission from your local sheriff to buy a gun. Why? Well, the sheriff can prevent you from buying a gun. Well, what do you think that was meant to be in 1930 or 1950 or 1960? How many times do you think black people tried to go get a permit to buy a gun and were denied? Probably a lot. Let's be real. A lot. Remember, most gun laws are racist in nature. Most gun laws against open carrying of firearms at times could be considered racist in nature. It would prevent black people from forming together for self-defense. There is a very common thing with that. You see that going forward with eliminating like Saturday night specials and cheap guns. It's meant to prevent people from buying guns cheaply, and that's typically poor people. Generally the poor and minorities. We don't want them owning guns. Why? Well, we can't have the darkies and the poor owning guns, is what a lot of those laws were focused around. Yes, MLK himself got denied. Correct, Isaac. Yes, The Racist Roots of Gun Control is a very good book, yes. Yamal says, wait, I think gun control's base now. It's like, no, don't be that way. No, bad chat. It's not based. No. Oh my God. All right, so they keep going and they talk about the McDonald court doing more. But then we finally get to the big one that matters, Bruin. And Bruin set forward that only if a firearm regulation is consistent with this nation's historical tradition may a court conclude the individual's conduct falls outside the Second Amendment's unqualified command. And then they go further. The Supreme Court thus eliminated the two-step test previously in use in many circuit courts, saying the tests employed are one step too many. And that was an issue. There was a ton of problems, and Bruin was meant to fix it. But guess what? It didn't fix it because courts are doing whatever the fuck they want. And they kept going. They kept going here. Yes, while you do have the need for self-defense in the home, most Americans hazard greater danger outside the home. Because guess what? We all have to leave our house. Even in the time of the Second Amendment, it kind of was a work from home lifestyle, but you still ventured out into the world. And there are highwaymen and roadmen out there you had to deal with. And Indian raiding parties, and the French sending a raiding party, or the British sending a raiding party. There were a lot of people you had to deal with. And they say confining the right to bearing arms in the home would make little sense given that self-defense is one of the central components of the Second Amendment. And it's not only just individual self-defense, but it's collective self-defense and defense from the government and defense from other common enemies. And they say the individual right to possess and carry weapons in case of confrontation, and confrontation can surely take place outside the home. And in Bruin, the Supreme Court said the definition of bear naturally encompasses public carry because obviously you can bear arms at home, but yet most gun owners don't wear a holstered pistol at their hip in their bedroom or while sitting at the dinner table or sitting at their computer. Now, yes, do I have anything on my hip? No, but I do have I do have a Beretta 92 here. I just decocked, and it sits with me at the desk. So it does work. It does exist. And then we get on to the bigger one here, Rahimi. And yes, tell that to New York City. Well, New York City has its own problems. Earl Word says, go worship black people quietly, Boomer. Well, okay, Earl, thank you. Do I have a box cutter? I got an X-Acto knife here. I mean, that's pretty close. Yes, keep your rifle by your side. So, we move on to Rahimi. And Rahimi just came out. This is one that, at the time when listening to it, it didn't seem like it was going to help a lot. And it actually, Rahimi kind of helped. I would argue it clarified things. So it wasn't as bad as I thought it was going to be initially listening to the oral arguments. I think we talked about them before, and I think I talked with Matt about these. Rahimi was very scary initially, but it turned out okay. So Rahimi clarified a lot of stuff. And they said, as we explained in Heller, the reach of the Second Amendment is not limited to those arms that were in existence at the founding. So that's a really good point. Like, look, it doesn't just go to muskets. Rather, it extends to all instruments that constitute bearable arms, even those that were not yet in existence. Yes, that's very good. And they just keep reiterating that because they're like, listen, you knuckleheads, this is courts. This is how it works. And they said, though, and this is the issue here, by that logic, the Second Amendment permits more than just those regulations identical to ones that can be found in 1791. So holding otherwise would be as mistake as applying the protections of the right only to muskets and sabers. Now, to be fair, I think that is a way to protect the idea that new guns were allowed and newer ideas were allowed. Well, then there's new ideas on restriction. So the challenge regulation becomes an issue of the court must ascertain whether the law is relevantly similar to laws that our tradition is understood to permit, and it applies faithfully the balance struck by the founding fathers. Now, Rahimi was about a guy who got through domestic violence, he had a protection order and he had a temporary restriction on his right to bear arms through a protection order under the Lautenberg Amendment under 922 G9. And the laws must comport with the underlying principle of the Second Amendment, but they don't need to be a dead ringer or a historical twin. And the burdens on the government to prove there isn't a historical analog to the modern prohibition in question that shows a historical tradition of regulation of the weapon in question. And guys, I already highlighted these because we just need to truck through these pretty quick, okay? And they say when an individual has been found by a court to pose a credible threat to the physical safety of another, that person may be temporarily disarmed consistent with the Second Amendment. And that is Rahimi's major holding. So at first you're like, okay, yay, this works. But overall, Rahimi was not that bad. It was not that bad. Now, we're not going to cover the issues here about dissenting opinions. I don't really care about the dissenting opinions here. We really need to get to... hold on, where do I have all of my notes here? We need to move on to where the court starts breaking things down. Like I said, this is 168 pages. If you guys want to read about all this, this is very good stuff to read. It's stuff I've read before. Like, obviously, I read this. It's a very well-written document. You guys should take your time and read the whole thing. But we're not going to go through all of it. I will say Justice Breyer's dissent in Bruin is actually very interesting if you do want to read it. It's interesting to see how, and it's a very interesting take on what they think the Second Amendment should be. But we're going to move on from there to the Seventh Circuit's jurisprudence, okay? So after the issuance of Heller, but before Bruin, there was a case called Friedman versus City of Highland Park from 2015, which is interesting because that's where the shooting that caused Pika to happen is from. So the case involved the constitutionality of Highland Park's own city ordinance possessing the possession of assault weapons and large capacity magazines. And we've talked about Freeman before. We've talked about Bevis before because we've covered some of these other actions that came through. Now, they went ahead, and after surveying the other circuits dealing with this, they came up with their own thing here. And they say, we think it better to ask whether a regulation bans weapons that were common at the time of the ratification, or those that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. And they go on to talk about whether law-abiding citizens retain adequate means of self-defense. And they say after pointing out that the arms banned by the Highland Park Ordinance are not like those existing in 1791, the court observed that because some of the arms in question were commonly used for police and military functions, they therefore bear a relationship to the preservation and effectiveness of a state militia. They said, though, but states which are in charge of the militias should be allowed to decide when civilians can possess military-grade weapons so as to have them available when the militia is called to duty. So here you go. That is some beautiful logic. Well, it's a military-grade weapon, therefore the government should, because it's meant for militia duty, well, then guess what? The state's in charge of the militia. So, yes, not all militias are not all state-run, but this government's never going to acknowledge this court right here in Friedman. The Seventh Circuit's not going to acknowledge you have the right to form your own militia or be part of the unorganized militia. They're not going to recognize that. They're recognizing the militia that gets called when the governor orders it, and it's the group of men who get called to muster. Friedman does concede that banned weapons can be used for self-defense. But they do point out that if criminals can find substitutes for banned assault weapons, then so can law-abiding homeowners. So there you go. There you go. There you go. And they point out that a ban on assault weapons and large capacity magazines might not prevent shootings in Highland Park, but they may reduce the carnage if a shooting occurs. I mean, and this is an awful, awful opinion, but this was case law in the Seventh Circuit. And this is the judge's way of pointing out how shitty it is. He says the best way to evaluate the relation among assault weapons, crime, and self-defense is through the political process and scholarly debate, not by parsing ambiguous passages in the Supreme Court's opinions. No, your job is to follow the Supreme Court's opinions. I mean, listen to the Seventh Circuit saying they have the right to do whatever. Now, we move on here. They talk about in the Friedman plaintiff sought certiorari, which got denied in 2015. So that was it. Two justices did dissent from the denial. Justice Scalia, praise be upon him, and Justice Thomas. So they did dissent, but the certiorari was still not granted. Remember, to get certiorari with the Supreme Court, you need 4 justices that want to hear your case. 4. If 4 of them agree, you get cert. So only 2 of them definitely would have granted it. The rest of them did not. So it was a 7-2 to deny. But they were halfway there. But we move on from there, and the big issues are, what do we do here? So this judge now determines, I've got to harmonize the Seventh Circuit and Supreme Court case law, because we've got to figure out things here. So the plaintiffs had to establish that the weaponry in question is an item an ordinary person would keep at home for purposes of self-defense. The weaponry in question is not exclusively or predominantly useful in military service, and the weaponry is possessed not for unlawful purposes. But he does say, however, even if the weapons flunk this test, it could still be considered an arm entitled Second Amendment protection if dual use is demonstrated. So he is going forward with the definitions here, and we have to define things. What do these words mean? We have to have that agreement. So what does bearable mean? It's like, what does bearable mean? Does it just mean bear arms? Or does it actually mean the arms from a bear? So, but even going forward, Justice Ginsburg, and this is from a case where Muscarello v. United States from 1998. She says, the most familiar meaning as the Second Amendment indicates means wear, bear, or carry upon the person or clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. So even Justice Ginsburg understands what bearable means and bearing arms means. And remember, Chad, it doesn't just mean guns. Technically, it means swords. It means knives. I mean, those are arms. They are arms. Now, going forward, the courts in the Seventh Circuit said, bearable thus must mean more than transportable or capable of being held. Well, yes, because there are weapons you can't hold, which are still bearable arms. So moving from here, the court does come up with its definition of bearable. And there are some issues here. And this is where I start to have problems with this case. And here's my thing. Is this judge doing it for political expediency? Maybe. Is this guy really believe this? That's the scary part. So they point out, is any handgun, shotgun, or rifle that could be picked up and carried a bearable arm? They say, is the ability to safely operate the weapon a function of whether it is bearable? They say some firearms might be so awkward, cumbersome, or ponderous to hold, aim, and fire, they may be inherently unbearable as a practical matter. Consider a firearm with a size or intense recoil such that it comprises the ability to be safely used properly for self-defense. In this category, it could be a .50 caliber weapon. Now we're starting to get to an issue. We're starting to get to a problem here. Yes, you're not going to hold a Barrett .50 cal rifle. You're not going to hold the thing. Most people would never do that, but you could deploy it on a bipod. And God, it rained again. Jeez. You could take a .50 cal rifle and put it on its bipod, and you could lay down behind it and use it, or you could put it on some sort of outcropping. There's ways you would deploy the weapon. That doesn't mean you're going to hold it. But this becomes an issue. Is he, because like I said before, chat, is he saying this for political expediency, knowing if he says you can have .50 cal weapons? Because PICA banned .50 cal weapons, 50 BMG weapons. Is he saying that because he's trying to get something through to the Supreme Court? Or does this guy actually think 50 cal is too dangerous? I don't know. That's a problem here. We don't know what this guy's thinking. And that, once again, this is a concern. Is this them like Boomer Con FUD? Or is this a guy who's thinking like tactically down the road? We have to win the battle for just AR-15s and then we could go back and get the Barretts. I don't know what he's wanting to do. Because it's not only this, but I couldn't hold an M240 machine gun and fire it accurately from the shoulder. But he points out most adults would struggle mightily to fire 5 rounds at quicker intervals because of the immense recoil. Well, if it's on the ground and it's properly deployed, You can go on YouTube. Dudes will rip off a string of shots with a Barrett, no problem. You know, they said, how do we treat a weapon that's only partially borne while operating it? I mean, yeah. Does that also include, like, if I have an MG42, like in a Lafette tripod mount? I'm not actually bearing it. I'm just sitting behind it and using it. Or they talk about remote control and radio-controlled weapons, which is a bigger and bigger thing now. We're getting to the drone warfare, especially in, Ukraine. We're seeing that more and more, like all the drone stuff. And they say this court, and this is him when he says this court, that means him. They acknowledge that such issues may be deemed by many relevant to be what is bearable. And they say, however, given the types of arms banned by PICA, these queries are more properly addressed in the definitions of other terms. And we'll get to some of this. And this, once again, I have concerns. So we have bearable. Bearable is a weapon that an individual carries for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. Good. So we've got a definition finally. We finally got a definition we're working with here. So, well, now with dangerous, and there's dangerous here. What does dangerous mean? The definition of dangerous is inextricably linked to that of common use. Because the Heller Court wrote that there's an important limitation on the right to keep and carry arms. Miller said, and this is talking about U.S. v. Miller, that the sorts of weapons protected were those in common use at the time. And they think that that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Okay, well, what's dangerous? Well, we've got to get to that. So they keep going here, and we get to, and this is once again where I think this is an issue. They cite one of the Seventh Circuit cases. They said everyone can agree, we hope, that a nuclear weapon such as the 51-pound W-54 warhead can be reserved for the military, even though it is light enough for one person to carry. Nope. If you can afford it, you should only be limited by what you can afford. Sorry. If you can afford a SADAM, great, you can afford a SADAM. Now, the Fourth Circuit says there are not the modern equivalents of weapons that were commonly possessed and employed by self-preservation by your shopkeeper, butcher, or blacksmith up the road in colonial America. They point out there are necessary things. Now, they point out the Second Amendment here is jealously safeguards the rights to possess weapons that are most appropriate and typically used for self-defense. It emphatically does not stretch to encompass excessively dangerous weapons, ill-suited and disproportionate for such a purpose. So does that mean a 60 millimeter mortar, grenades, a Claymore mine, a M240 machine gun is not appropriate? Well, we're going to get to that. Now, they point out there are issues here when identifying what is an arm protected by the Second Amendment. They say, is this a fair reading, or rather, is it an attempt to strangle the more full-throated test of the Supreme Court? Is there a different test for arms in common use, but the principal purpose is for hunting or competition shooting instead of confrontation? And they say, what about big game ammunition? And guys, the ammunition you would use to go take out a deer, is a Remington Core-Lock 30-06 round different than 30-06 ball ammunition you'd shoot out of an M1 Garand? Or is a varmint round, if you were to shoot a varmint round out of an AR-15 at a person versus a armor-piercing round, is that different? What do you make of a flare gun? The general purpose is to help identify a location or signal distress. I can still shoot you with a flare gun. If you guys have watched The Road, you could get shot with a flare gun. I would not want that to happen. That would be really bad. But the dictionary definition of dangerous is able or likely to inflict injury or harm. And he says clearly the ability to inflict injury or harm applies to all guns. They are designed to maim, wound, and kill. Thus, all firearms will be considered dangerous. They said, however, considering the weapons the Supreme Court has said are not covered by the Second Amendment, machine guns and shotguns that are sawed off, but they are used by the military. I mean, World War I, they were in common use. Guess what they had in World War I? They had self-loading rifles. There were self-loading rifles. There were machine guns of all sizes and types. There were all kinds of mortars and grenade launchers and rockets and other explosive weapons. And guess what would be really great in a trench? A sawed-off shotgun. Although really, and if you're like doing a trench raid, you probably would be better off with a sack full of grenades and a pistol with a couple magazines. And in fact, if you guys have ever seen pictures of the stormtroopers in World War I, some of them just carry these big sacks of grenades under their arms. Because by the time you're in a trench, just throwing grenades down the trench as you went would probably be a more effective weapon. Little bombs clearing out trenches are going to be more effective than the weapons available at the time. Trench gun would be good, yeah. But even then, a cut-down trench gun. 10 KVs is a pistol with large mags. Yeah, it would be. But if you didn't have access to a Luger with a trommel magazine, one of the big drum magazines, a Luger with like 15 or 16 pistol magazines would be my next alternative. Or like being one guy with 6 guns, like 6 pistols on you. So you could just boom, 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 boom as you go. And then while you're doing it, throwing fucking grenades. Like, yes, that would be the better way to do it. Now, yes, if you had like an MP18 and you could just hose a trench down, great, but you might have reliability issues. Meme Copium, Josh, how are you doing, man? Guys, Meme Copium, he is on fire right now over on YouTube. He is keeping it on lock in Japan, the land of Shinzo Abe, of Abe-san. So, guys, give him a look. He covered some Nick stuff this morning. He did a really good job with it. Hope you're doing well over there, Josh. Yes, the POH Schnellführer. Yes, all kinds of things. Cass says, how fast am I running? I'm not running. My friend saying they banned trench guns. No, they did not. They kept using them. Shotguns were not banned in World War I. The U.S. Army kept using them all the way through. And interestingly enough, in the first aerial conflicts, the pilots initially waved at each other. And then after a while, one of them pulled out a pistol and tried to shoot the other one down. Well, that progressed quickly to you had a buddy in your back seat with a rifle or a shotgun trying to shoot the other guy down, which then quickly turned into using a machine gun in the back seat, which then quickly turned into putting machine guns on the front of the plane. And then you had, dogfighting and the normal things from there. Yes, the U.S. said, LOL, no. And that's basically what happened. The Germans said, please don't do this. And America said, lol, nope. The Germans were threatening to execute Americans found with shotguns. And then we said, we'll execute Germans we find with butcher blade bayonets. And we'll do whatever. If you start executing our soldiers, we will execute yours. So the Germans backed down very quickly. Yes. But remember, guys, shotguns were not a common thing in Europe because hunting, and this is a side tangent, but we're going to talk about it real quick. Hunting in Europe is traditionally the sport of the elite. It wasn't a common man's thing. You didn't need it to survive over there because that wasn't a thing. Because hunting, you were hunting the king's deer, and there's a reason why that was. If you were the monarch of a country, you don't want the men of your country going out in the woods on their own in groups. And, when you're out with a group of guys hunting and you're using bows and arrows or earlier weapons, guess what you're doing? You're doing hammer and anvil tactics. You're doing movement. You're engaging and you're trying to drive the prey to the guys with weapons. You're driving that. So guess what you're doing? You're doing coordinated movements over distance. It's basically fire maneuver. You're doing maneuver warfare. Granted, you're hunting things, but it applies to people. And then you're practicing with your weapons. You're living off the land. And while you're doing all of this, you're engaging in basic soldiering skills. You're, navigation, survival, and you're building camaraderie. Because hey, hey, all the bros from the village, we went out and hunted. Isn't it great? We have a bond now. That's military development. Monarchs didn't want that. You don't want an unorganized army you don't have control over operating out in the woods. Because guess what they might do? They might go, we could turn around and fucking kill the king because he's a dick. Well, that's a problem. Here in America, that wasn't a problem because everybody just does their thing. That is a very common reason why hunting is predominantly for the elites. It was never a thing for the ordinary man in Europe. So that's why we went on that tangent real quick, chat. Now, this is a problem I have going forward with the dangerous things here. He says a machine gun is dangerous in the same way as is a flamethrower, an explosive, or a chemical or biological weapon. In its normal mode of operation, it is extremely difficult, if not impossible, to control the weapon or to fix it on a discrete target. I mean, a machine gun does. A machine gun has even a machine gun, when you have it set on a tripod, you have what's called a beaten zone, like an area the machine gun's kind of like recoiling in. It's a very definitive area. You can do very good damage with it. You can burst fire it. In fact, with a machine gun, you're firing, 3 to 5 shot burst. It's very accurate. But notice this is where they are. They say when fired in fully automatic, an M16 or other fully issued firearms like the M249 SAW or the M240 Bravo machine gun provide suppressing fire, meaning it's not designed necessarily to hit targets, but rather to lay down a blanket of fire to cover a fire team or other unit's movement. Yep. The infantryman requires a high volume of accurate fire to suppress an opponent in a position. And it goes on to further talk about more about what the purpose of suppressing fire. It's so you can keep the enemy's head down, so that you can find and fix the enemy, and by fixing, you move on them. You find, fix, and fuck them. Keep their heads down. Call element A's. When you're doing this, you've got element A, and they're shooting at the enemy right here. Here are the bad guys. While they're shooting, element B is right here, and they roll around and attack. It's fire maneuver. It's flanking. It's doing all that fun stuff. So why is this a thing here? Well, they say these are not precision aimed fires, and it is very unlikely the enemy is visible to the approaching forces. This court notes that this occurs in military tactical situations only. These weapons are imprecise as an inherent part of their normal operation, even when used by trained and skilled military personnel. Thus, it stands to reason that an untrained civilian shooter would have even less control over a machine gun, or for that matter, flamethrower or grenade. Such weapons would maim or kill an attacker, but the operator would not be able to control the weapon's discharge in a reasonable manner. This quality, the inability of the shooter to control the weapon, is a workable and reasonable definition of dangerous, in line with Supreme Court intentions. And he says, put another way, dangerousness is not linked to the control of fire, not the rate of fire. So, thus, machine guns would not necessarily be banned because of the rapidity with which they deliver rounds downrange, but because the average civilian operator, and as it turns out, the military operator, cannot control the weapon when fully automatic in a way that would ensure the reasonably aimed shots. Such weapons would not be used for self-defense in a confrontation with a discrete, identifiable opponent, rather than used in military settings against concealed targets. Using in a machine gun in a self-defense situation result in rounds being fired toward random or unintentional targets. So you see the problem here, chat. The problem here, chat. This is the problem. This is the problem. This is the problem. CyberRat says, yes, he said, I fired an M249 with great success under control. Yeah, if you guys go on YouTube, you can see videos of U.S. servicemen taking saws, M249 saws, and just laying down hate with them. There's actually like a really good one where like the Doom music kicks in and this guy is getting shot at. He just comes out around the corner and lays down like a 200 round burst. He burns through a whole saw magazine, just hosing down this road like 100 yards away. It's actually pretty cool. CyberRat says, I hate the 240 though. Okay, well, I'm half Mexican and half Canadian. Sorry, SA. Sorry. Oh. Commando says, now teach the L-shaped ambush. Yeah, well, we save a lot of that for locals. So this is once again the problem here. I have a fiery Latin temper. Yes, I have the passion. Oh. Now, this is, once again, guys, this is the scary stuff here. This also applies to sawed-off shotguns for similar reasons. Decrease in the length of the barrel decreases not only the effective range of the weapon, but its precision as well. To put another way, the projectiles will spray in a wider pattern because of the diminished length of the barrel imparts less control on the trajectory of the projectiles. This is where I have problems, and I said this before. This is bullshit fun logic. That is not correct. You know, a shotgun's pattern, you know, with buckshot, for example, like buckshot patterns out of a shotgun at range are not that different. Like are not you know, they're not huge. They are not huge. Like buckshot patterning in a shotgun, chat. I mean, here's a great example of it. Since I can't show you the gun being fired, we're gonna use this. This is at 21 feet. This is at 21 feet. How buckshot patterns. Tim says the choke determines spread. Even then, the choke is like, look at the size. At 21 feet, you're generally going to be on one person at 21 feet away. That's all inside your chest. So this is a problem. Like in video games, you know, they talk about you know, like when you're in a video game, you can kill like 3 guys at once with a shotgun. That's not how they work. You can get like a duckbill device that kind of spreads, but even then, that's obnoxious. At 7 yards, double-aught buck. And this is 3 separate rounds. This is 3 separate times they fired double-aught buck. So 3 rounds of double-aught buck at 7 yards. All right? That's what we're dealing with there, okay? So 3 times they shot. At 7 yards at 21 feet. You know, there's a lot of fun, and Jardis, I think this is the thing. There's a lot of FUD lore here, which is a problem. There's fucking FUD lore in permeating this. Because look at this. Look at this. At 7 yards, 3 separate rounds of double-aught buck, and it's all right in the middle of the A zone of a target. Even if you did this at close range. So think about in your house. And this is the thing you need to consider, chat. In your home, what's the distance you're probably going to shoot inside your home from like wall to wall? Like shooting, you know, from your front door to the longest spot in your house. Maybe it's down the hallway. Maybe 20 feet. Maybe 20 feet. For a lot of you, it's going to be even shorter. So look at that. 20 feet away. And you have buckshot in a shotgun, you have to make you have to precisely shoot. You're not able to it's not a street sweeper. You're not blowing out the whole hallway with that. You still have to make your shots count. Danny's saying, were those federal flight control? Even then, it's still tough. It's still tough. I mean, at 10 feet, you know how big that's going to be? At 10 feet, you have like a fist-sized hole in a guy's chest. The buckshot is not properly deployed at that point. At 10 feet, you are basically punching someone with a solid slug. And with a sawed-off shotgun, I mean, it's not as though you're shooting like with a 2-inch barrel. I mean, generally, you're shooting with like a 12-inch barrel roughly, or a barrel's roughly as long as the magazine of your shotgun. So if you cut down like an 870 or a Browning A5 down pretty far, you still got a pretty decent shotgun. Like, you're still accurate for what it needs to be. Yeah, you're not trap shooting, but that doesn't matter. That's not the issue, and I agree. And yeah, Maddie, a sawed-off shotgun does not shoot like it's spraying sand, but this is that boomer's argument almost. When, this FUD lore here, the way he's talking about this, you think like he thinks there's going to be like, when you shoot somebody with a sawed-off shotgun, he must think it's going to be like, you shoot right here, you're aiming at this target here with a sawed-off shotgun, okay? He says you aim at this guy. He must think this happens when you shoot. That you end up with like, like you hit everything. No, you don't. You don't. Even with a sawed-off shotgun, at 10 feet inside your home, even at 7 yards inside your home, look, a full-size barrel is keeping it all in the A zone. You might have a bigger shot like that, but that's still, you aim at a man, you kill the man. And the bigger issue is for a shotgun, chat. The bigger issue is for a shotgun. So, like, let's say you're aiming at this guy here. Sorry, I'll put it back up. He thinks you're going to aim, like, over here. There's going to be pellets going all the way over here and all the way over here. That's not going to happen. The bigger issue, though, for any sort of weapon you're using to kill somebody is over-penetration. Because to reliably kill someone, you have to be able to penetrate through their entire body. Because the FBI says the minimum penetration for a fatal wound and for rounds to be effective for their definition and their purposes is 12 inches of penetration. Okay, yes, fisting in the A zone. Got it. Okay. No, we're not. That's the advice Steel Toe and Nick have, okay? That's Aaron Imholt's advice. We're not talking about that, chat. This is just garbage, though. If it's strong, like, here's the thing, chat. If you have a weapon that's powerful enough to kill a man, it's going to penetrate through him. So penetrating through a target is always a concern. And here's the thing. Anything that will reliably kill someone will penetrate through an entire body. So you just have to be mindful of your target and what's behind it. Yes, the average adult male chest depth is 10 inches. So that's the issue here. There's some things where this guy's based, but there's also, this definition of how this all works. He's not citing anything. This is fucking FUD lore. This is FUD lore at spots. This is FUD lore, chat. We can't have FUD lore on the bench. And they say sawed-off shotguns suffer a similar defect. Scattershot aptly describes discharge from the shot-off shotgun at point-blank range. No, it does not, you boomer fuck. No, it does not. So anyways, dangerous. He says, as bearable arms that a typical operator cannot reasonably control to neutralize discrete identified aggressors. Once more, it is the lack of ability to discriminately control the arm and its discharge projectiles that make it dangerous, not its rate of fire. Okay. So we move on to unusual, meaning uncommon or rare. All right. So historically, usual weapons for confrontation included knives and spears and swords, clubs, bows and arrows, and bullet-firing weapons like pistols and rifles, and projectile-firing weapons like crossbows. Today self-defense weapons include tasers and pepper spray. So there's two qualities that make an arm unusual. The first quality is the atypical way in which the arm neutralizes an opponent. The second is an arm that harms or an opponent in a way that is repulsive. Now, they point out it's odd to contemplate that when the purpose is for lethal defense, but nonetheless, that would be chemicals like acids, which would inflict horrible pain and leave permanent scars, or arms that eject blister agents and arms that use lasers to blind an adversary. That also means poisons, radioactive compounds, biological agents. So you can't have anthrax set up for self-defense, chat. And they say that there's an element of cruel and unusual in accordance with the Eighth Amendment here. They say, we have banned weapons for use in war because even in a war setting, they are so cruel, brutal, indiscriminate, and inhumane as to prohibit their use. Well, the 1980 Convention on Conventional Weapons banned poison gases or non-detectable fragments, landmines, incendiary weapons, poison bullets, cluster bombs, and other biological weapons. See, here's the thing. We are not signatories to this. The United States is not. The United States is not a member of the Landmine Treaty, is not a member of the Cluster Munitions Treaty. We are not actually a part of any treaties, really, except for like the Non-Proliferation Treaty. We are not controlled by any of the arms control regimes at this point, really. We never have, and we never will be. So they talk about also technical advances and improvements are expected and not unusual. He says, as an example, prior to 1950, almost all rifle stocks were wooden. So he goes on to say that unusual means they emit lethal or seriously harmful explosives, chemicals, or any NBC type agents, oral weapons, or directed energy weapons like lasers. So does that mean going forward, if we do develop lasers, does that mean a laser gun? It's like we develop a las gun. Does that mean that's an unusual weapon? Technology will progress. I mean, eventually we will be able to have miniaturized blasters. That's going to happen. Or as citizens, are we limited to metallic cartridge weapons going forward? And the military can have laser guns, but we are stuck with kinetic weapons. Something to think about. That is a very scary thought there. That is a very scary weapon. It's a very scary idea. Meme says the phrasing of the stream, my God. No sound devices? Yeah. Well, I think that also goes back to when we've heard of we've seen the riot control issues where they use the microwave weapons and the high intensity sound. Can't use that stuff. How about rice in a self-defense? Probably not. No, oral. AURAL, like auditory weapons. Yes, been there, done that. Says Claymore, Claymore. Yes, hit the clacker, chat. Hit the clacker. Yes, the brown note would be another one. Yes. Nico says the rods from God are still kinetic. Yeah, would a railgun count? How does a railgun work? Because a railgun's a kinetic weapon, but it's being used electronically. Once railguns are handheld, how is that going to work? And, handheld or shoulder-mounted weapons that deploy high thermal energy would also fall under the category of Second Amendment. And that's where, we talk about this. I think this guy, if laser guns were available tomorrow, a Star Wars blaster, he would say that's a bannable. You could ban that and restrict it. Which, once again, is fucking scary. Because not only do we need to protect the law for ourselves now, but 300 years down the road. What's it going to, in 100 years from now, we'll probably have laser guns. I bet within 100 years, we will have laser guns. If not sooner. So looking at the items banned by Pika, the only items that fall under this category would be grenade launchers and belt-fed munitions. Grenades are included because no one uses them for self-defense. That's because they're not available. That's because they're not available. If I lived in a house by myself and a group of people were attacking me to kill me, guess what I would use? I would use a fucking grenade and clear out the house. Yes, Eraser was a fun movie, yes. This is an issue here. Yes, in Sweden, the nation of Sweden is unavailable for comment. Yes. Yeah, like I would use flash. Like if somebody broke into my house and I had access to flashbangs, I would use a flashbang. That would be very effective. You might light your house on fire, but that also, you might not have to kill anybody. Belt-fed machine guns are included because civilians simply do not purchase firearms in which cartridges are fed through a belt rather than housed in a cylinder or magazine. That's because you can't get them! Nobody you're buying a like the amount, like, hold on, hold on here. I can't do, I can't show it because I'll probably get fucking pinged for it. But the NFA market board, it's just... like right now, a guy on Sturmgewehr is selling at sturmgewehr.com. They have an NFA board where you can sell machine guns. Guy right now is selling a fully transferable 50 cal machine gun, an M2 Browning machine gun with the tripod mount, the anti-aircraft mount, the traverse and elevation, the headspace and timing gauges, linkers, so you can link ammunition, an extra barrel. Chat, how much is that? It was posted 6 hours ago. Tell me how much you think that is right now. Tell me how much you think that is right now. An M2 machine gun. A Browning 50 cal. Just take a guess. Take a guess. $65,000. $65,000. Yeah, you aren't going to be like, nobody could buy one because you're buying a fucking house at that point. It's house money. $65,000 fucking dollars. Like, it's fucking insane. And also subguns. Yeah, got the NFA sales tracker. Where is it at? Where is that? Because wait, is it subguns? Yeah, the machine gun price guide. Here we go. So this is, if you guys ever want to know what the cost of, let's say, let's pick here a gun we all know. An Uzi. Okay. We're going to share this tab because it's not sharing a gun. This is the cost of an Uzi right now. This is the tracking of it. All right. So what are we seeing? Oh, hold on here. Who's messaging me? Who is messaging me? All right. Nobody, it looks like. So if you guys zoom in on this, this goes back to October of 2003. So right down here, October 2003, right down here at the bottom, okay? At that time in October of 2003, you could buy an Uzi, roughly the average price, at least the price is being reported. This is all self-reports and information available. About $5,000 you can buy an Uzi. April of 2024, the most recent data. On the high end, about $23,000. The low end, somebody sold theirs for around about $15,000. The average is about $20,000. Okay? So there is it's not fucking cheap. It is not cheap to buy a machine gun right now. Yeah, MP5s are like $30,000. There's all it's getting ridiculous out there, chat. Belt-fed machine guns. We'll go to a belt-fed machine gun here. We'll do another one. We'll do a belt-fed machine gun. An MG42. How about that, chat? How about an MG42? You know, just like in Saving Private Ryan when they're on the beach. Bzzz. January of 2004. January 2004. What were you looking at? What were you looking at for an MG42? And I hope the list is wrong because we can cover. We can clip this later. Somebody can clip it for me. An MG42 in 2004 was like 30 grand. Now look at the prices. This is like it. The curve is more of the average here. Look at the prices. Some of these people are paying retarded prices. $75,000 for a machine gun. Or if you want to buy an M240. An M240, chat. You know, an M240, and there aren't too many of those. It's also known as a Mag 58. You know, in November of 2003, you're paying $100,000. December of 2023, when one was for sale, $375,000. $375,000, chat. $375,000. How much for a saw? I don't think there's any saws available that are not dealer samples. I think there might be one or two pre-86 saws available. So the saws, to do a saw, you're going to have to get a dealer sample. Meaning you'll have to be an SOT. So that a saw is pretty much non-existent. But even, for example, we could just do like a Lewis gun. A Lewis gun from World War I. In February 2004, you get one for $10,000. In the prime of the World War I stuff, like the .303 caliber Lewis guns with the Pan magazine on the top, like look how retarded the prices got. You know, it's on average, you know, one sold at a fire sale price. Whoever got that got a steal. But the average right now is about 30-some grand for a machine gun that's going to be over 100 years old, likely. Very likely. And let's just go to regular machine guns. Like an M16, you know, not even that. Not even that. We're going to go to auto sears. Because we can show an auto sear. So a lightning link, chat. A lightning link. And real quick, this is something you can put into an M16. And it makes it full auto. Okay. Let me show you here. It's literally, it's the whole auto key card thing, okay? This is a lightning link. Right here, this is it. It's literally a piece, 2 pieces of steel. And you put it inside your AR-15, you literally open it up, and you drop it right in. It's literally a thing. It's literally like that. You could go to Home Depot and buy the metal to make that. It is literally that. It is literally that, chat. It is literally that. So you guys want to know what an AR-15 lightning link is right now? Here, we'll do that, and then we're going to move on. We're going to move on. There's a reason why people can't afford machine guns. And hold on here. Where is... So in January of 2008, you could buy a lightning link for less than probably $5,000, $6,000. December 2023, and you know what? It's only gone up since then. I do know this because I know I've seen sales since then. It's over $35,000 for a lightning link. Yes, you heard me right. That little piece of fucking metal is $35,000. It's fucking insane out there right now, chat. Why don't you show guns again? Because we get nuked when it happens. YouTube doesn't let you show guns. So I'm just saying, guys, this, remember the FNC auto sear scam? Yeah, rip Scarboroughs. Yes, very true, Jose. Hope you're doing well, man. But here's the thing. A drawing of that puts people in jail. A true story. Yep, Matt Hoover with the CRS auto key cards. We had Matt from Fudbusters on to talk about that. And we'll have him on to talk about the appeal because the appeal has been filed and we're waiting to see what's going to happen. But guys, this is the bullshit logic this judge has put together. You know, civilians simply don't purchase these firearms. They can't afford them. If they could, they would. If I could have a saw in my house, I would have a saw in my house. If I could have an MP5, if I could have a fully suppressed MP5 in my house as my go-to weapon instead of an AR-15, I probably would have that instead. I probably would. Or at the very least, I'd have a full auto AR-15. So I'm ready to use it if I need to. If it's time to get down, I'll fucking get down. But if I could have a fully suppressed MP5, I'd fucking use one. And I probably would have sitting in the closet next to it a fucking saw gassed up and ready to go. Because if it's fucking party time, guess what? I'll bring the fucking saw out. I would if I had one. So, yeah. Jard is saying a suppressor is more important than full auto. It is, but if I can have both, I'll take both. But yes, if I could just have a fully suppressed MP5, SD5 without all the hassle, I'd be using that too. If I can have some, like, suppression is important, but also having fire superiority is very important. Both are important. Are we invited to the party? No, you don't want to come to that party if that's happening. If I'm trying to kill, if I'm using a gun for social purposes, you don't want to be around. I'm just saying, guys, this is bullshit. Annie's saying, whoa, I have a full auto. No, I wish I did. I don't have that kind of money for a full auto. So this is just the fucking garbage here. This is just the absolute garbage of this nonsense. And Ag, yes, the prices for these guns, because, well, for example, all these guns that are out there for sale have been all made prior to May 19th, 1986. So they're, by all default, they are all almost 40 years old minimum. But for example, those MG42s are from 1940s from Germany. But by default, all machine guns that are legal for civilian possession are older than May 19th, 1986. There are some exceptions, guys. Don't get into me like, what about the Stempel M60s or all the other bullshit that's out there? Yeah, there's a lot of exceptions that happen throughout the 80s and 90s and even in the 2000s. But for the most part, any machine gun you're going to buy is at least a minimum 40 years old. Minimum. So, but yes, people would buy them if they could fucking get a hold of them. Once again, this is bullshit FUD logic. FUD. Matt, we need you here. We need you busted FUDs. So here you go. Unusual is defined as an arm deploying an atypical method to neutralize an opponent in confrontation that deploys a neutralizing agent that is caustic, incendiary, noxious, poisonous, or radioactive. Well, does that mean that mace? Because mace, like pepper spray, is noxious. I think he made it clear that it's not. But it is still noxious. It's a noxious fume. Unusual will also include those weapons that are not designed for successful self-defense and neutralizing an opponent, but are primarily deployed to inflict cruel, brutal, or inhumane suffering on a person. Well, going by his logic of cruel and inhumane and suffering, can I use lead round-nosed ammunition? Because that would qualify as a dum-dum bullet. And expanding ammunition is not allowed under the rules of war. Like in the military chat, military ammunition is all full metal jacket. They might use ballistic tips a little bit, but basically everything's ball ammunition, full metal jacket rounds. Because you can't use hollow points. You can't use lead round nose. You can't have lead tipped ammo. You can't have expanding ammo. Well, does that mean hollow points are legal or illegal? Does that mean I can use, like I said, Remington core locked ammunition? Can I take a box of deer ammunition and load it up at a 30-06 M1 Garand and fucking shoot somebody with it? Or is that illegal? This is not clear. This is not clear. Jose's like, yes, most MJ42s in the markets are Yugo's M53s imported before the 1968 import ban. Yes, there are a lot of them. But, yeah, I mean, based on this logic, it sounds like this judge would ban you from using hunting ammunition on a person because it's expansive and it's banned by, military convention. Yes, New Jersey already bans hollow point ammunition. But based on his logic, because he was going on and on about all the things that are prohibited by treaty, expanding ammunition is banned. So like dum-dum bullets, lead round nose bullets and just lead tipped bullets will expand. You can't have those either. That would be retarded. But you have states like New Jersey where you can't have expanding. You can have hollow point ammo. Does that mean if I take like a bunch of Hornady, or even Barnes ammunition, solid copper rounds, solid copper ammunition, which is designed to just fucking tear apart your targets. Barnes TSX ammo. I load up a bunch of those in the AR-15, or even better, 308 stuff. I load a couple of those up in a G3 and fucking air condition subdue with them. Is that legal? It sounds like it might not be, which is an insane proposition. Yeah, Barnes TSX ammunition fucks. It fucks really hard. No, the Barnes Ammunition Company, chat's different. Not by Robert Barnes. Yeah, if I used a flare gun. I have like a Polish flare gun and a Yugoslavian flare gun. If I let's say that's all I have left in the house. Some guy breaks in and I shoot him with a 25 millimeter flare and light him on fire. Is that legal? Is that legal? I don't know. It doesn't sound like it would be. So I'm just pointing out these are problems here. He talks about common use. So he's already has definitions for bearable, dangerous, and unusual. So what's common use? And the Seventh Circuit states that AR-15s have been sold to the public since the expiration of the federal assault weapons ban. Is not dispositive whether or not they're in common use. And they point out that suppose, for example, a new type of handgun is introduced on January 1st. As of that day, 0 guns have been sold, yet if its characteristics are analogous to many of the other types available, no one would say that this new one is not within the class of arms protected by the Second Amendment. And they said at the other end of the spectrum, consider the actual case of machine guns, for a time which were available for civilian purchases, but were eventually withdrawn from the market. Yeah, they were banned from the market. However, popular machine guns might have been either in organized crime circles or more generally, because their characteristics were military in nature. The decision to reserve them to military use was in the power of the legislator. They point out one brief asserts at least 25 million AR-15s and similar rifles. That includes, I would argue there's probably at least 20 million, but I'd say a majority of those are AR-15s, but you're going to have AKs, G3 platform rifles, various FN platforms like the FN-FAL, the FNC. You're going to have all kinds of stuff, SKSs. There's all kinds of semi-automatic weapons out there. The plaintiffs assert at least 150 million magazines with a capacity greater than 10 rounds have been bought. I don't think that's impossible. There's no way to know because magazines are not serialized. There are cage codes on them, but that doesn't mean shit. A lot of them don't have cage codes. So, there's just gajillions of magazines out there. Gajillions. So, and they point out that, even if an AR-15 is unusual, they're not more dangerous than a handgun. And they say, recall, the test is dangerous and unusual. So we get to what do we do with all this? Now we run into problems, and this is where they talk about Garland v. Cargill, the bump stock case, which once again, that was a good thing. But they talk about Sotomayor saying, this language rings close to a statement that such rifles are in common use. Oh, yeah, there's a bajillion bump stocks at the time. Now, the issue here is that common use is not a mathematical equation, okay? If the number of sold is essentially irrelevant, but if raw sales data is not determinative, then what is? You know, at some point, we do have to look at, well, how many people own them? You know, it's at some point you have to do things here. But this court, and they're going to say this court here, holds that any bearable rifle or pistol that is capable of semi-automatic fire and is or has been available for purchase by law-abiding citizens is presumptively in common use, provided that is not otherwise dangerous and unusual. So the court's going to skip all the recitation of sales data for the different firearms. And they also point out that sales data may not be readily available. You know, and it's not always known. People don't like disclosing how many guns they have. But the annual data collected by the Annual Firearms Manufacturing and Exporting Report is limited to production numbers, not ownership numbers. The data does not distinguish between modern sporting rifles and other rifles. It includes rifles that are ultimately acquired by law enforcement as well, yeah. So, this court defines common use as any bearable rifle, shotgun, or pistol that's capable of semi-automatic fire. And see, here's the problem. He's throwing automatic weapons under the bus. Has been available for purchase, possession, and usage by law-abiding citizens for self-defense, provided it is not otherwise dangerous or unusual. Moreover, for the sake of clarity, the court will also include essential features like magazines and non-essential features that increase operability, accuracy, or safety, like the various attachments that PICA prohibits, which include like flash suppressors, you know, bump stocks, grips, forward grips, all of that, as items that are presumptively in common use. So it sounds great. It sounds great. I mean, doesn't it sound good so far, guys? Doesn't it sound good so far? Well, what can we do more with this? What more can we do with this here? Well, they go on to talk about, you know, to begin, soldiers, Marines, and airmen have deployed with various other pieces of equipment. Kevlar helmets and body armor. Load-bearing vests. Yeah. So there you go. Like, I do think that he's at least acknowledging you have the right to protective gear as well, which is helpful. Which is helpful. Jardis is saying this part is entirely reasonable. Yes, but this part, are you talking about yes, the part about the attachments is entirely reasonable. And other things. Now they talk about troops going into harm's way as a trained unit supported by air cover reinforcements, medical support, naval support, and reconnaissance, and intelligence. The smallest infantry unit is a fire team. It's a group of 4 infantrymen leading a team leader. And you could break down a fire team in elements, but yes, riflemen, automatic riflemen, and a grenadier. Yes, and he's using various Army manuals here, various FMs 3-21.8. Now, we don't have those. So they point out that and he goes on a little bit more, the M16 M4 is not primarily a suppression weapon. For that reason, every unit, including the 4-man fire team, carries a machine gun designed for suppression to allow the rifleman to maneuver and close with semi-automatic fire on the enemy. Yes, and that's the purpose of the automatic rifleman. He is to lay down a base of fire to allow movement. Then it gets to civilian self-defense. It is not about crime reduction. The focus is self-defense and the ability of each citizen to be able to repel an attack by one or more adversaries or to offensively engage an adversary to protect oneself and others. You may have to defend yourself or family from home invasion. Often you're ambushed and are struck with the weapons that he or she has available. You also may be called upon to defend others who are not armed or almost certainly will not have time to plan or regroup with other allied defenders. Additionally, combat in the home or property may draw you away from ammunition supplies. Moreover, firearms are normally in a home kept under lock and key so children can't get them or those who might self-harm. So in that situation, the accuracy, safety, ease of use, and magazine capacity of a defense weapon may literally be the difference between life or death for the civilian. And the civilian has an army of one. You have no backup. You have no support. You have no medical support, fire support, QRF. No one's coming to save you the moment when your confrontation occurs. They will often have the same physical fitness abilities as trained soldiers. Moreover, they will not have the benefit of military training and conditioning on which they can rely in a life or death scenario. Their firearms have both lethal capabilities and give at a minimum our citizens a fighting chance. Therefore, sorting between military and private use is an exercise in understanding civilian self-defense. So, there are complex dynamics of self-defense in which lethal force may be required to repel a rapist, or murderer, a kidnapper, or a stalker. What about community self-defense? If you have to defend your neighborhood from rioters and looters or bad guys in general. Notice he's not getting to that. There are simple self-defense where, one person confronts the other in his or her home while armed with a pistol or a shotgun. And that's straightforward. However, we consider that the only scenario, then the search is woefully inadequate. Considering that one scenario does a great disservice for people who face confrontation. Unlike in the military, you might be infirm, disabled, or small-statured, and you would not qualify as being combat ready. Certainly, yeah, most people aren't. To be fair, though, the same principles apply, though. Fighting a bad guy in your house, the rules apply. The same rules apply. And, close quarter combat, the same rules apply. You're generally on your own, which means you don't advance. You generally defend. Considering only self-defense scenarios also ignores the right to keep and bear arms applies to any and all lawful purposes, not just self-defense in your home. To confine the right to the home would nullify half the Second Amendment. And we already talked about that. That's something that's happened before. So consider scenarios in which the choice of a weapon would confer a tactical advantage. It could mean the difference between survival or death or serious injury. A stalker and a victim, which, assaulting the victim while they're at home or while in transit to their workplace or at their family's home. Somebody testifying about gang activity and is in danger of serious harm for the gang members. Witnesses a serious or violent crime. Defending yourself at home against multiple aggressors. Or consider where you've been abandoned by law enforcement for a variety of reasons. Meaning, remember, chat, law enforcement has the duty to save you, but they might be engaged, or they just can't get to you, or they're indisposed because there's a riot going on, and you're on your own, just like the Koreans in Koreatown in LA. They had to take care of business. So this is just Krusty Kovacek says, I can't stay for long. Can we own assault rifles in Illinois again? No, not right now. There's been a stay put on this ruling for 30 days. And they've already appealed it up to the Seventh Circuit. So no. Right now you cannot. Right now you cannot. Sorry. That's the short TLDR. TLDR. So there's another story regarding confrontation and armed self-defense where it's serious contemplation. At the conclusion, and this is actually something, if you guys have never heard of, this is actually important. And somebody's like, oh, Sean, talking about black people again. Well, this is where shit happens. So at the conclusion of the bench trial, this court invited the parties to tour the 24 sacred sites of the East St. Louis race riot of 1917. Some of those sites are adjacent to the federal courthouse in East St. Louis, which is in Illinois. East St. Louis is not a nice place, chat. East St. Louis is pretty rough. Either across the street or within a few blocks of the courthouse. Heading into the July 4th weekend of 1917, it turned into a race riot where it was a 7-day pogrom of killing blacks. Over 100 black men, women, and children were killed and lynched, burned alive, or drowned. Many were burned out of their houses. The National Guard was present, but didn't actively get involved until the third day. The highest-ranking member of the black guy in the East St. Louis Police Department watched as a mob burnt down his fucking house. Fortunately, they could escape. But a lot of people didn't escape. So, there was a mob stopped a streetcar and attacked black passengers. 6 black people were beat to death. The black man was lynched. When an ambulance arrived, they threatened to kill the ambulance driver. I bet each one of those guys on that fucking stock car, that streetcar, would have loved to have had a fucking Beretta. Why would I need 15 bullets? I could think of 15 reasons. So, not only, there's all kinds of examples, though. It's like you guys have seen the picture where there's 30 people standing around the black guy getting lynched. I'm sure he wished he would have had an AR-15, because I'm sure he would have killed every single person in the way. So there's another story. Scott and Iva Clark. Rioters set fire to their house where they hid in the cellar. And as the walls collapsed, they fled to the next house only to see it on fire. And they fled again, making it to a National Guardsman whom they assumed would protect him. He did not. The husband was struck in the head with a bar and a noose was looped around his neck. And because they couldn't lynch him, they drug him through the streets. All kinds of people fucking died. But there were spots where a couple of black guys took up positions, and after a few shots, the mobs retreated. Site 11, over 100 black people barricaded themselves in 2 homes, and they were armed and resisted so much the rioters complained to the Illinois National Guard. And one of the National Guard officers lectured the rioters that they're playing the game the way you are. And, that's funny. It's like, they're not allowed to shoot back, sir. And he's like, this is the game. They're playing back. So there are history. People getting fucking killed over shit. The Koreans are a great example. Koreatown in 1992. If you guys want to see some epic shit, go watch the footage of that, where guys are standing out in the street with fucking pistols chasing off rioters and gang members. This is. Shrek Gordon said, "What started that riot? I don't know, but either way, whatever it was did not call for burning out half the town and killing every black person you could find. I'm not sure what caused it, but it got out of hand." So the choice of arms, and it says, Seneca wrote, "Nothing happens to the wise man contrary to his expectation, because the wise man's considered every possibility, even the cruel and heartbreaking ones." Well, in self-defense involves decisions that maximize tactical superiority. That first decision is fight, flight, or surrender. And so if one could get to a safe room, that would establish the tactical advantage of invulnerability. So, you have to, there's all kinds of considerations. What are my options? And we need to get to, we're going to skip ahead a little bit here, chat. So the plaintiffs propose findings of fact and conclusions of law. And we are going to get to what I think is interesting here, because the court does cite some interesting facts here. And now, obviously, they talk about all the different types of weapons that are available. But I do think it's interesting. Where are we at? Next page. So here, the government's own expert indicated that at a minimum, millions of Americans own AR-15s at this moment. Estimating the number of Americans who own an AR-15 at 14.1 million to 18.2 million adults. And that's just AR-15s, but that also includes, think about it, that also includes people who take an 80% lower and make one, 3D printed guns, all kinds of shit. All kinds of shit, chat. Oh, what are we doing here? No, it's not a shower text, chat. It's a friend. What? It's already midnight. Well, we need to get going here. So, oh, fuck. I got to take a look at something later. So, how many of those AR-15s at the bottom of, I don't know. So it's just important to notice that there are 18, millions and millions and millions. But we also have problems here. We have problems here. So there is a big problem here that we do have problems with. This is still going to allow 50 cal ban. That this is still going forward. This is a problem here. This judge is still going to allow the 50 cal ban to stay in place. So, I mean, that's a problem here. He does not get rid of it all the way. And I don't like that. I do not like that, the fact he will do that. So that being said, this court is not convinced that any law-abiding citizen would keep a 50 cal at home for self-defense purposes. The same is true for the ammunition it fires. This court holds that outside of 50 caliber rifles and ammunition, 50 caliber pistols and any belt-fitted weapons have no lawful self-defense purpose. But 30-round magazines, the various attachments, meaning grips, flash suppressors, and the like at issue here, these devices are also common and have legitimate self-defense purposes. Unlike the military, a defender will usually only have what you can carry. And that's true, guys, for self-defense situations. Like if someone breaks into my home right now, yeah, I've got a gassed up pistol sitting next to me. I'm not going to be able to have a bunch of magazines with me. Generally, you're going to run what you brung. So, for example, someone wakes up, comes in my house in the middle of the night, the AR-15 and, ready to go is that's probably all I'm going to have access to. So, yes, more rounds equal a higher chance of survival. Yes. No one has ever said, oh my God, I brought too much ammunition. And if you ever watch any of these interviews of like the Sean Ryan show or some of these other things, people have been in combat. Nobody's like, oh my God, I brought too much ammo. No, they're like, oh my God, I didn't bring enough once. and it was scary. So this is a problem here, though. I mean, the court holds that grenade launchers are not in common use for self-defense. Grenade launchers are listed as attachments that, if attached to a rifle, converted to an assault weapon. There is clearly no lawful self-defense purpose for grenade launchers. I mean, having less than lethal capability is a good idea. You know, if I could load up a 40 millimeter beanbag round and shoot a guy with it, if I could do that instead of shooting him in the face with a 5.56 round, maybe I'd want to do that. Maybe I don't think I just want him off my property, like out of my house. Maybe I want to shoot him with a Baldo round. Or, Splinter Cell, use a sticky shocker. There might be ways you want to do that because, even in Ohio now, courts acknowledge it's not just using deadly force, but you're repelling attackers. Well, if you're in my house and you won't, I will repel you. And if I can repel you with less than lethal means, I would rather do that. I don't want to have to kill someone. If I can use less lethal means, I would rather use those at times. Jason Lazat says a sticky shocker. It was back in the early 2000s, there were these experimental 40 millimeter rounds that were being developed that when you shot, they had this like sticky glue on them that would attach to you, and it basically was like a taser round. And it would shock you like a taser. So it was an actual thing. They didn't work because they realized they couldn't deliver enough shock. But you're getting hit with a 40 millimeter projectile on top of it. So this is the problem, chat. This is the problem here. And they say attachments, and here's the other thing, attachments that increase the firing rate must also be discussed here. PICA refers to external devices that may be attached, like bump stocks, binary triggers, auto sears, and the like. So the issues here, they point out that while the plaintiffs have not presented evidence to indicate they're selected for self-defense, the court holds that regardless, they don't fit within the definition of dangerous because dangerous is not related to control of fire. It's related to the control of fire, not the rate of fire. So I may be able to shoot 1 million rounds a minute, but if I can control it, then it's safe. No evidence has been presented indicating that bump stocks, binary triggers, or similar devices result in the operator being unable to control the weapon which they're attached. The language regarding devices that increase the rate of fire is vague. Therefore, the court's lacking data. And because it lacks data, it's going to presume they're okay. So we're starting to get to some problems here. Once again, there are issues I do not like about this ruling. There's shit here that I do not like. I do not like this. So, here's the issue. And the court ultimately gets to military use. It refers to weapons that are selected, procured, tested, and issued to military members for use in combat. And it says, with this in mind, none of the weapons, magazines, or attachments prohibited by PICA could call military grade since they were not issued to the military for use in combat. And he says, even if in arguendo there are no material differences between an M4 and an AR-15, so-called dual use has been established. And they say, obviously, many weapons are dual use. Private parties have a constitutionally protected right to keep and bear them, and the military provides them to its forces. And they, because here's what they say in Bevis. When we say military weapons, we mean weapons that may be essentially reserved to the military. So, with all that, he says that The court holds dual use refers to weapons that, while predominantly useful in military contexts, are also useful for civilian use in confrontations, such that would be covered by the Second Amendment. So he's fleshing a lot of things out that I think overall are good arguments. But here's the problem. What he's excluding is very concerning. It's very, very concerning. It's very concerning, chat. I do not like it. And you get to the features. There are features on weapons that are a bit of an issue. And they argue that, and the plaintiffs point out that if every AR-15 in Illinois was used in a mass shooting, then 99% of them would never have been used in a homicide. And he points out that mass shootings are such horrific and traffic accidents are clearly outliers, not the most common use for semi-automatic assault weapons. The court also notes the government has previously stated that firearm data showing that semi-automatic rifles are both dangerous and unusual is unattainable, even though it's required under the Illinois statutes. So, while this court holds that 30-round magazines are not possessed for unlawful purposes, this court does not make findings on magazines holding more than 30 rounds, as neither party has produced sufficient evidence for this court to make determinations of whether they're in common use or used for lawful purposes reserved for the military. Fucking pussy. Once again, we're getting into FUD territory here. You might find FUDs who are okay with 30-round magazines, but they're like, why you need that drum mag, boy? There's a big problem here. I have a big issue with this. I should be able to own fucking drum magazines. So, they also say, apart from magazines, the court also holds attachments of banned by PICA, including foregrips, flash suppressors, barrel shrouds, and the like, are not possessed for unlawful purposes, but rather legitimate features that enable the rifle or pistol to be fired more safely and accurately, and that protect the operator from flash blindness and other conditions that would impede his or her ability to defend himself or herself. This does not include grenade launchers, which do not have a lawful purpose. Fuck you. Fuck you. Is bullshit. Now, the argument about banning AR-15s because they're easily convertible to fully automatic is nonsense, because it's not permissible to ban all shotguns because you could simply saw down the barrel. So that's good. I mean, that's a good argument here. This guy has some sound arguments, but he has some really shitty application of these arguments, and that's the problem. That's the problem. He has a lot of, his reasoning is great, but his application of the reasoning is bad. So it's so fucking bad here, chat. Going on. So this court holds 50 caliber ammunition and weapons restricted by PICA are not arms. So yeah, 50 cals. Therefore, Illinois can lawfully ban 50 caliber weapons and ammunition. Build-fed weapons and grenade launchers. Pussy faggot. And that's why I hate this part here where he goes on and talking about the Constitution. It's like, fuck you, you sellout. I don't like that. That's part of this. Ultimately, it pissed me off when you read through this. Most of this, it's just ball washing. Okay, well, the peasants can have their AR-15s and that's it. No, that's not where it should stop. So, the concluding observations. Sadly, those who seek to usher in a sort of post-Constitution era where individual rights are only as important as they are convenient to a ruling class. Seeking ancient laws that may partner well with a present-day infringement on a right without reading it in conjunction with the aforementioned history is nonsense. The statute of Northampton, and that means Northampton, this goes back to what they were citing, cannot in the least bit be used to vex the rights of Illinois citizens in the 21st century. The oft-quoted phrase that no right is absolute does not mean that fundamental rights precariously subsist subject to the whims, caprice, or appetite of government officials or judges. And I did save that little bit. That last line here is pretty epic. So for the reasons set forward above, the government's motion for partial summary judgment is granted. Most importantly, considering all the evidence presented, the court holds the provisions of PICA criminalizing the knowing possession of specific semi-automatic rifles, shotguns, magazines, and attachments are unconstitutional under the Second Amendment to the United States Constitution as applied via the 14th Amendment. Therefore, the request by the plaintiffs for a permanent injunction is granted. The state of Illinois is hereby enjoined from enforcing PICA penalties in accordance with the law for bump stocks and assault weapons, the attachments, and large capacity magazines against all Illinois citizens effective immediately. As the prohibition of firearms is unconstitutional, so is the registration scheme for assault weapons, attachments, and magazines. Therefore, the state of Illinois is enjoined from enforcing the registration requirements and penalties associated with entering false information or on the endorsement affidavit for non-exempt weapons, magazines, and attachments previously required to be registered. This injunction is stayed for 30 days, which allows the state of Illinois to appeal. And they did. They're seeking appeal. And yes, Stephen P. McGlynn, yeah, he did an overall okay job. But once again, this was the issue. His application of that was awful. Was awful. Jose says, weren't most rifles in 1776, 75 caliber? Yeah, 70. Well, they were greater than 50 cal. Now, typically when they mean by 50 cal means like chambered in 50 cal BMG or 12.7 millimeter is the metric designation of 50 cal. 12.7 millimeters, chat, is 1/2 inch. 25.4 millimeters or 2.54 centimeters is equal to 1 inch. See, that's the, if you want to teach kids the metric system, teach them about firearms. So there's 12.7 millimeter machine guns. That's a cartridge made in Russia. There are other 50 cal cartridges that exist out there. But yes, that's generally what they're talking about is like the Dushka round or the 50 cal BMG round. But yes, even today, most modern muzzle loaders, inline muzzle loaders, are 50 cal or greater. So, yes, Matthew is saying it's written for particulars to be too muddled for SCOTUS arguments. Yeah, this is, like I said, I fucking hate how it's done. So, for where are the factual findings in this derive? Based kind of, he's a FUD. He's a gun shop FUD, and that's a scary part. It's slightly better than, dealing with people. Jard is saying the Dishka does not equal the M2. I understand. They have it's a different length of cartridge. But when I'm saying the 50 cal band, they're talking about like, the 12.7 millimeter by 99 millimeter, and then whatever the Dushka round is. Hold on here. It's like 107. Hold on. What is that? What is it here? Hold on. 50 BMG is 12.7 by 99. And then there is the equivalent. What's the Russian equivalent? What's Dishka rounds? The Russian version is 12.7 by 108. Sorry, not 109. I was pretty close. Chat. So, Maddie, I think he was trying to put a slash in there. No, they operate different length cartridges. They're different cartridges. Oh, means equals the same. Oh, well, why would you just put an equal? I thought he meant to put a slash in there because that means does not equal. So, very problematic, chat. I do not like it. But we got some super chat stuff to catch up on. Jardist Says machine guns have always been legal federally. You need the NFA forms, fingerprinting, and pay the tax. Yes, but there are states that prohibit the possession of machine guns. Suppressors are greater than an auto weapon. I don't disagree. But if you can have both, Hannah Montana and get the best of both worlds. Another says, how about a Frank's hearing? Lars Larson says, can I say I'm a proud gay nibba? Yes, you can. Abel says, do you think Trump will appoint Brandon Herrera Supreme Court Justice Judge in 3 years when Thomas retires? No, and I wouldn't want Brandon Herrera to be that. I think Brandon Herrera would not want to be a judge. He knows his limits. I mean, like, what's he going to rule on otherwise? So no, I wouldn't want him to be that. I don't think he'd want to be that. But no, hopefully he gets involved in the, Second Amendment stuff in the government. The Kansas-Missouri Act was a deal with the devil. Yes, it was. There were a lot. Well, people were trying to avoid war. They were willing to try to avoid it, and they didn't make the right decisions. Ag says Kansas is still insane. Bleeding Kansas is where the border war rivalry between Missouri and Kansas started. Yep. Jose Rodriguez for $10. Thank you for being here, Jose. Says, fun fact, the Texas Supreme Court ruled in the 1890s. You had the absolute right to own a howitzer at home. It took more than 2 years for them to say it applies to civilian guns. This is why felons can own guns in Tejas. Interesting. Jose says, meanwhile, in America, we had 75 years of practice with shotguns against Indians. Yes. But also in general, people had a shotgun for natural going around and out and about. Even people who lived in cities, sports shooting was always a thing. Takedown shotguns were very common. Bebop says this sounds Bebop Rocksteady says sounds insurrection-y. Yes. Jose is also saying back in 2016, before their bet on Hillary winning bankrupted them, my local Gander Mountain had the semi M249 for sale. Yeah, I've seen those. They look pretty neat. It's just at that point, the cost for one, it's like you could buy like a thermal with an Ecotty, which would be pretty epic. Tim of Tams. Tim, how are you doing, buddy? Gifting 5 subs. Let's go, chat. Let's go. Thank you for the support and the generosity here. Anything Goes says, these guys lied. I demand a Frank's hearing. I agree. There should be a hearing. There's lying everywhere. Jose says, I miss the days of $10,000 M16s. Jose, I've seen the machine gun ads in the 90s. Like 1995, you could still buy like MP40s and tube guns for like under $2,000. I've heard the stories of buying an M60, a Sarco M60. Or is it Seiko? It's Seiko. I'm sorry, it's Seiko. S-A-C-O. A Seiko M60. For like $2,000 in like the mid 80s, like before the ban happened. Like I've heard of all kinds of crazy shit back in the day. Jose says, do you remember the scam where the NFA dealers were ping-ponging MAC-10s on the paperwork, changing them one letter at a time until the MAC-10 said M1919? Yeah, so if you guys weren't aware, people were taking a gun like a MAC-10, which is like a $5,000 machine gun, and they would take the serial number, cutting it off, and they would graft that number onto guns and make new machine guns of greater and greater and greater value till you basically launder that serial number into like a $100,000 machine gun. So you take like a MAC-10 serial number and graft it onto like a BAR, a Browning automatic rifle, or an M60. Well, the feds cut onto that, and so people paid dearly for trying to fuck around that way. Yes, and the FNC Auto Sear scam. Yes, rip Scarboroughs. Yeah, and that's the thing, Chad. If you guys if you don't know this, the NFA thing is full of people trying to fuck around and come up with fuck games. That there are times where there's cheeky things you can do to play with the ATF, but a lot of times when you play with the ATF, you're playing fuck games and you're going to get your dick smacked. So, and there's a reason why you're thinking, oh, well, could I do this with a machine gun? Somebody's probably already tried it, and the ATF has said no. Swizgar says, my buddy, a civilian, owns a Fight Light belt-fed AR-15. This is bullshit. Yeah, but Fight Lights are still pretty expensive anyway. They're not cheap. President-elect Phil Sweth, who's been a member for 11 months, says, turn the block party into a Glock party. Yeah. Get your blickies, chat. Get your blickies with your switchies. That's all that matters.
Switchy. No talk. No cap. No talk.
That's right, chat. No cap. No cap. And Jose, we already talked about this, but yes, a lot of the MG42s are Yugo M53s, which are basically the same thing, but there are some World War II era MG42s out there. Jose is saying, loading up a chopped down Zastava M76 with B Patron is still kosher in most states. If you guys don't know what B Patron is, during World War II, the Russians and the Germans had exploding ammunition. So it looked like normal issue ammunition that would explode on impact. The bullets had a little bit of explosive in them. They were initially meant to be marking rounds for machine guns. So that way, when you're shooting the machine gun, you could see the explosions and aim and correct fire. Because unlike a tracer, because when you're shooting tracers, if you ever watch those videos of World War II of like airplanes getting shot at and there's tracers everywhere, you could follow the tracers back to the gun that's firing it. Exploding ammunition doesn't allow for that. It's only one person can see it, the guy shooting it. Well, after a while, B Patron, and I forget what the Russians version was called, started ended up getting in the hands of snipers, and the snipers started using exploding ammunition on each other. Very interesting. Simo Haya, he got hit by a round of exploding ammunition. That's why his face looks like it's melting. By the way, NJ's Hollow Point ban exempts possession at home. Really? Well, that's good to know. I thought that would. I thought it was a complete ban, but that's good to know. Thank you, Jose. Jose also says, wouldn't Catano versus Massachusetts protect laser guns? No, I don't think so. Hey, guys, Catano was a Supreme Court case where a woman in Massachusetts, because she couldn't get a hold of a gun, tried to get a taser for self-defense from a stalker, and she was denied. So she had to go to the Supreme Court, and the Supreme Court's like, Massachusetts, you're being fucking retards here. She should be allowed to do this. Jardis is saying, how is a street sweeper any more dangerous or unusual than a semi-automatic Benelli, like a Benelli 1301? I don't know. And, if based on like watching Forgotten Weapons, apparently shooting street sweepers are very uncomfortable because the stocks are shitty. And, having to wind up the drum on a gun is a pain in the ass. Yeah, I don't know. But that's, don't give them ideas. Don't give them ideas. Cedar Rose gifted a membership. Thank you, Cedar Rose. Thanks for the support and the generosity. That's right, chat. Keep praying the gray away. We have to purge the grays. Convert them. Then Jose says, the point in Illinois, black powder guns are considered regular firearms, so they should introduce a 75 caliber musket into evidence. Yeah, I don't think they were thinking that far ahead. And I think the guy would make the judge would distinguish a black powder firearm from a self-contained metallic cartridge in a Barrett a Barrett M82 or in a Barrett M107. Like, I think he would distinguish the difference there. EDW Raptor really wants the Grays to go away. Tell him you keep moving, Grays. This is a green neighborhood with 10 subs. So there we go. Purge the glowies too. Yeah. Yep. Yes. Oh, Rock and Roll Tyrannosaurus says muzzleloaders are exempt from PICA. That makes sense too. But thank you for that. Thank you for that info. Although I'm surprised it is. Let's see here. So what you're saying is Yak Gotti should be acquitted of a felon in possession of a machine gun. He did get acquitted. The judge did a directed verdict on that. She said that it wasn't his. So I don't think he had to got that one. This just in, Russia's bombing the shit out of energy centers in Ukraine. Ooh, lad. Yeah, that was a matter of time because we're getting into the winter. They're gonna freeze. It's gonna be a long winter in Ukraine. That's a shame. You're saying, "Wow, what are we?" You're going, "Wow." What are you guys talking? Unload the grain in the round, underload the grain in the rounds, or you might be making a splinter. What are you guys talking about? What are you guys doing here? Wooden guns have a short lifespan, but they would work. Yeah, yeah. So you guys are talking about making homemade guns here. Anubis said, "Did you get my message about the LA riots?" I think so. I actually I don't know. Don't know. It's Boolean algebra. I don't. Do I look like I know what that means? Do I look like I know what, like, I have a grasp of algebra, sir? Do I look like that? Do you think I'm here because I know algebra? Do you think I went to law school because I know algebra? You forget yourself, good sir. Oh, he still got the felon in possession charges? Oh, okay. So. Oh, Matt said he was talking about Abe. Well, yeah, but Shinzo Abe, the gun wasn't wooden. It was a pipes taped to a wooden thing. So the pipes can, the pipes can handle a decent amount of pressure there. Can anyone see your post? No, we cannot. Yes, of course we can see yours. Yeah. Jardis is saying yes and no. I'm not sure what are we yes and knowing. Yes, lawyers could do math. Yes, I can count money, but that's about it. Yes, rest in peace, Abe-san. Yes. Hmm. Thoughts on self-defense punji pits? Booby traps are not a good idea because other people. It's like a spring gun. Spring guns are a no-no. Punji pits would be likewise a no-no. Children could wander onto your property, or for example, like a fireman could show up at your house trying to help you. He's going to get stuck, but also you'll get stuck. So don't do it. Don't do it. Never a good idea. You thought you got shadow banned again? Yeah, no, you're here. I see your comments. You've been in here. I've seen you here. Terry Bollea algebra equals Hulk Hogan math. Boolean, yeah, is and or and Zor for yes, no. Oh yeah. So why can't I super chat? I don't know. Every once in a while, YouTube does that. Like it's fucking weird. Every once in a while, I don't know what the deal is. It's YouTube. YouTube, they're afraid of your power. They're afraid of your power. Whoa, 17 bear bombers and the blackjacks are up. Woo! Wow, they're even throwing the blackjacks in the fight. That's interesting. If you guys don't know what the Tu-160 is, basically it's like a B-1 bomber on steroids. It's massive. God, they're going to missile bukkake a lot. Those bears, 17 bears, that's a lot of calibers. That's a lot of calibers. Ooh. I mean, I'm surprised there aren't MiG-31s chucking Gonzales up too, but good Lord, chat, watch out. Jose is saying, are there any actual laws banning possession of recreational nukes if you pay the $200 tax? I don't think there's any laws, but you're going to have Department of Energy regulations because remember, the DOE is in charge of nukes at the end of the day. Even though the military has nukes, the DOE oversees all that. So you would probably need a lot of DOE authorization for that, and you're probably never going to get it. How many blackjacks do they have left? I don't know, actually. I know they have enough. I'm surprised there are 4 of them that are operational. I mean, those things are maintenance queens. Let's see here. How many do they have left currently? Well, there were 32 total built that were active, and how many are left right now? Let's see. So, oh yeah, they built 4 new ones. There's like a newer model coming out. The 4 of them have been built. But let's see, what are they? How many do the Russians have right now? Let's see, what's the total number? There's about 20 or so total in current use. About 20. So they're like about 25% of their fleet is fighting right now. Jay says, where can I keep abreast of news in Ukraine? Twitter is actually a very good spot for that. I mean, if you can read Cyrillic, go on Telegram, but if you can't, Twitter's not a bad place. You go to Forum 1 or Forum 4 or Nuke, like you can, like it's on there. It's on there. The amateur iconoclast has no Tu-22Ms. They're not built for that purpose of, launching. Also, that's going to be more naval aviation anyway for most of the Tu-22s. And those are actually like they got to be careful with those. I mean, it's the problem with the backfire is like there's it's more about naval aviation being out there for that. And they have some of them. I think they deployed a couple to Syria, but I think allegedly, like the beginning of the war, they used them, but they've really kind of like not used them a whole lot in the meantime. But like, what are they? Hold on here. Who is the operators? Yeah, they have like 57 left. And there's a bunch of them, but a lot of them are out like on, like I said, naval aviation. And they're mainly like a lot of them are like out east. So there's not a ton of them around. Let's see. I have authorizations called nuh-uh. Battle says the Tu-160 looks like the B2. You mean B1. Hella says, please cheer me up. I have no internet except cell. Or no. That's not good. The cable's down. Did a koala bear eat it? Did the dango eat your internet? Luke says, so 21 blackjacks left? That's actually funny. You're a funny guy, Sully. You're a funny guy. Maddie says, yeah, it's like a Forum 6. Yes. Hold on here. We'll Google it. We'll pull it up. Okay. All right. Here it is, chat. We're going to do this. Hold on here. All right. This is a Form 6. This is the application and permit for the importation of firearms, ammunition, and defense articles. Pretty sure it's on here. Where is... Actually, is it on here? The defense articles and ammunition. Hold on here. Yeah, the ATF form for nuclear weapons. Which one is it here? Would it be the Form 1? I don't know. I'm trying to figure out, chat. Yeah, I can't find it on here. Sorry. The backfire is ancient. Yeah, well, it's not that ancient. I mean, here's the problem when you say ancient. When people think of an airplane that's 50 years old, we think of the F-4 Phantom. The F-15's 50 years old. So, I mean, the F-15 has been around for, hold on here. Like, here's the thing. When you think of an airplane that's been, you think of a 50-year-old airplane, you think of this. Here. You think of that. You think that's 50 years old. That's not, that plane, it made its first flight. The first flight of this, the first flight was 1958, 66 years ago. 1958. The F-15. You guys, you know it, you love it. The F-15. Chat, like, just so you understand, the first flight for the F-15 was 1972. The introduction date was 1976. Like, when you think of 50-year-old airplanes, this is a 50-year-old airplane. It's ancient, too. K.E. Poles says, why do I want the government to know what guns you own? Because I don't want them to know. They don't need to know. Why do they need to know what I own? That's the issue. Why do they need to know what I own? Scott says, has anyone seen April and Helen in the same room? Oh, no. That's true. Jose is saying the Texas Criminal Supreme Court, and that's the thing, chat. Texas has its own criminal Supreme Court that handles cases. Says it's kosher to indiscriminately shoot in a group of people if it's a mob attacking you. And I think that a lot of courts would agree if that question were posed to it and the right facts. But yes, an undistinguishable group of people attacking you probably would be fair game, but consult with a local attorney where you live. You're going to have to do that on your own. So let's see here. Sean's trying to get me back into PPL ground school. You could tell the F-15 was modeled using early computer efforts, yeah. F-4s were built into the 80s, yes. Yes, the KC-135 is old, yep. Let's see, what else you guys have? Say, do I want certifications of people who own guns like a driver's license? Nope. Nope. I mean, for right now, like, I just printed out a 3D printed 22 caliber gun that I'm going to work on after we're done here. We might go sit on Rumble for a minute and play with it, trying to fit it up. I don't want anybody to know that I built this. The government should have no knowledge I built this. I don't want the government to know what I own. The government shouldn't know whether or not I own a crate full of AK-47s that I buried out in the backyard for a rainy day. They should never know any of that. So, the 810's is old too. Yeah, it's all old. Yamal for $5 left you speechless. Well, thank you. Just leaving everybody speechless, chat. Roosevelt Media says, are armed Baldos constitutional? I don't know. That there might be a human dignity issue under the United Nations, whether or not you're actively allowed to hurt someone's dignity using those. That might be a problem, chat. That might be the bit of an issue there. I would be concerned about that. Helen says, you all wish I'm here alone. Maybe I found a nice brown buff fiery outside this morning. What the heck are you talking about? I hope you're doing okay, Hella. Should a gun owner be mandated to train with the gun he owns? No. The government should not be involved in that. Would I hope if you own a gun, you know how to operate it safely and you can operate it efficiently and do so in a competent manner? Yes. But I mean, we have people take a driver's test, and how many people fucking suck at driving still? So, would armed Baldos need import stamps? Wilder is saying, do non-proliferation treaties supersede U.S. law? No. The Constitution is the supreme law of the United States. Any treaty signed by the United States is subservient to the United States Constitution. So a treaty cannot, like, let's say the United States, Joe Biden signed a treaty tomorrow agreeing to ban guns. Would not work because that treaty would violate the Second Amendment. Treaties cannot violate the United States Constitution. We do not allow for it. It is the supreme law of the land. The Constitution über alles. Coming down with a cold? I don't think so. Today was like we've kind of had the warm weather, cold weather, and then I don't know, something happened. I've been sneezing my butt off today, so I don't know. I don't know if an allergy thing or something. Oh, Hella's saying a fiery is a fireman. Oh, she got a buff fireman. Oh, yeah. Very nice. Fiery is Aussie for flamer. Okay. KE Poll says the Wild Wild West, absolute chaos. Now, here's the thing. Here's the thing about that. When you think of the Wild West, what is the most famous gunfight in the Wild West? The OK Corral, right? That's the most famous gunfight, right? When you think about it, how many people were involved in the OK Corral? It was Wyatt Earp, Morgan Earp, Virgil Earp, and Doc Holliday versus the Clantons and McLaury's, right? That was it. I mean, when people talk about the Wild West, the most memorable gunfight in the Wild West is this right here. This is the OK Corral. It was 4-on-4, and they shot maybe a handful of gunshots total. Think about that. That is one of the more famous gunfights in the Wild West. Or if you do another famous Western gunfight, you know, like if you Google famous Western gunfights, like they Google them. How many of them can you find? Like here, this is, you know, we'll use Wikipedia for a second here. Like because when people make these arguments, and I'm not picking on you, I'm just saying this is something to consider when these arguments are made. Well, what does that actually mean here? Because that means a specific thing. Like, so here's a list of gunfights, Old West gunfights. So the gunfight, let's just pick one. Wild Bill Hickok and the, you know, or like a duel in 1859. It's a famous duel. Okay. But let's pick the Battle of Blazers Mill. That's part of the Lincoln County War. So like, but Billy the Kid. So I would consider that its own separate thing. But you have like a famous one here is 4 dead in 5 seconds. 4 dead in 5 seconds, chat. That is a famous gunfight in the West. And this is one I've actually heard about. It's pretty cool. Yeah, 8 total people in the OK Corral, but this one here, it's Katie Pohl says, I want people to promise to not kill me or my neighbor. Well, generally people aren't going to kill you like as a normal thing. Like, you know, my neighbors don't come up to say, Sean, I promise I'm not going to kill you. Like, I don't walk down the street and go, hey, Bob, promise not to kill you. No, like there's generally a presumption people aren't going to kill me. But this is an example of a massive gunfight. This is probably one of the more famous gunfights in the West. And when you think about here's the thing. Witnesses generally agree this thing lasted no more than 5 seconds after the first gunshot. And, you know, a marshal accounted for 3 of the 4 fatalities. So I'm just saying, like, this is going back to this list, like, look how long this list really is. Like, a lot of these are, you know, like, what exactly are these at the end of the day? Like, how many people were involved? So, like, the Columbus shootout here. You know, you have things where people like politicians are running in a local sheriff's race. You know, and there's some basic feuds that have been brewing, and a person or two gets killed. Like, there's not a like. I mean, this is for the entire like Wild West and going back earlier. There's not a ton of it, and like what they call the Bellevue War. I don't even know what the hell this is. 1840. So what was it? It was a posse victory. They arrested somebody. Okay, so they went after a group called the Brown Outfit. Let's see what this is here. Okay, so it was a posse led by a group against W.W. Brown. Political tensions dated back to 1837 when Yankee businessmen caused problems. The settlers banded together with a wealthy hotel guy, W.W. Brown, who provided them a credit. So there was a shooting. So the sheriff was a political opponent of Brown and authorized a posse to apprehend him. The posse moved in on the hotel, and he accidentally discharged his weapon, causing a gunfight to break out. And 3 more people were killed on each side. The posse set fire to the hotel and attempted to capture those who escaped. And the guy was sentenced to receive a whipping and commanded to leave the county. Okay. 3 dead, 1 wounded, 3 dead, 1 wounded. Like, I'm just saying, this is not exactly the Wild West was not littered with bodies, I guess is my point. People like to think the Wild West was bad. It was actually pretty tame. Yeah, there was it was dangerous at times, sure. But in general, you weren't like the bigger threat was the environment. Like nature was trying to kill you on a routine basis. So, like it happens. It happens all the time. So I'm just pointing out that this is not a common thing here when you look at all this. You know, like here's one, the Vaudeville Theater ambush. Okay, so 3 guys got killed. Okay. All right, so there you go. 3 guys got killed at that. Let's see if there's other ones I haven't heard of before. And I just Googled this. I didn't know there was an actual thing here. You can look for all these. But I mean, it's not that bad. The Wild West was pretty tame. So people cared more then and about murder. The stakes were higher. Yeah, well. Wilder's saying, admit it, Sean, the white on white gun violence used to be out of control. You know us white people can't trust Whitey at all. You're correct. Kay Pole says, I think the proliferation of guns in the U.S. is sheer madness. Well, I mean, there have been a proliferation of guns since it was the frontier. I mean, that's the thing. Like, that's part of the issue. America's had guns since there were, you know, like the settlers were dealing with the Indians. Like, it's kind of a thing. Like, you know, like that's part of the argument here. That's part of the issue. You know, people don't like it, but it's like guns have been around since Jamestown and going to Massachusetts and the Pilgrims. Like it's I'm not going to tell you it's like it's all in the game, but we've been having guns everywhere since the beginning, man. All the settlers have been strapped. Like that's just how it is. I mean, I will tell you the proliferation of guns is madness. Yeah, but you come to America. It's pretty fucking safe. I mean, I live on the edge of Cleveland, Ohio. There are some neighborhoods I would not go into. Like if, like I don't carry a gun during the day because I'm an attorney. I go to court all the time. But like, are there areas like I feel pretty safe going to most places I go? Yeah. Are there places I won't go? Sure. And here's the thing, like if I think I need a gun, I don't go to that place. But yeah, it's overall pretty safe here in America. Like I said, not trying to pick a fight with you. I'm just using it as a good example of the history of America's pretty safe for the most part. Heading into bed, gun. Thank you. You heading to bed. See ya. All right, it's 1:00, guys. I didn't know we were going to keep doing this for a bit, so Andrew Jackson had more gunfights than most of the Wild West did. Yeah. So Maybe you hear that. That is something. It's a 22 caliber gun I'll be testing out tomorrow. So Matthew says the Rock and Roll Hall of Fame worth a visit. No, I have never been there. I have never even been there. It's. I don't think it's worth a visit. It looks all cringe and horrible, and I've never been there. I think it looks ridiculous. So that's all I'll say. I have drunk the Kool-Aid. Well, I have drinking a lot of Kool-Aid in my time. Look at me. I am a product of high fructose corn syrup. So yes, I've had a lot of Kool-Aid. I mean, like I really do. Like I really do have a, well, here. Are we clear? I do have a gun sitting here next to me. Like, we're ready to rock and roll. Like a real one, and then one that's been partially printed. So how many guns have I lost in a boating accident? I don't talk about that. Rough times boating, chat. Rough times boating. Keypole says, you guys with all those guns, I only have what I need. Well, I need these. So I have what I need. I'd like more, though. No ads. Guys, I don't know what to do about the ads. YouTube's doing it. I don't get it. All right, chat. We're going to land the plane here. Oh, Jose's saying, when I lived in Houston one year, we had 3 separate incidents where homeowners with AR-15s tied each other for the most home invaders killed at once, 4 apiece. Good. I hope that fucking worked, and I hope the other one survived long enough to get criminal charges. So that's awesome. Good for that. Good for that. But yes, never know when you have to fight a lot of people at once. Never a bad idea. Katie Pole says, nuts do not kill. Well, I mean, D's nuts are pretty lethal. I can tell you that much. D's nuts. The Rock and Roll Hall of Fame is gay. I mean, it looks kind of gay, but I mean, I've never been in it, so. Tenoct91 says, I'm in the UK. I've never held a gun. Well, that sucks. They're so much fun. So much fun to go shooting. Even just on a range is a lot of fun. Matty B says, J. Are we doing Rumble tonight? Nah, I don't think so, chat. No. It's a little late. We got morning to do. I thought we would, but it took me a little longer to get ready than I anticipated. So no, sorry. We'll probably play with the ghost guns on Friday night or something, or on Friday. We might do like you know what, chat? We'll probably do like a day stream during Friday, and we'll probably play with this. Working on the Hitchhiker live. We'll probably work on that because I need to put that together, and then I'll probably work on it, see if I can go to the range nearby if it's open and try it out. So. Most Hall of Fames are gay. The Hockey Hall of Fame is pretty fucking cool. Wilder's saying Netherlands here, never held a gun either. Well, that sucks. They're a lot of fun. You get the power knowing you take a man's life. Actually, no, it's not that bad. It's just they're a lot of fun. They're a lot of fun. J-Rock says, whole turkey or breast for Thanksgiving? We are not doing a whole turkey. We don't have enough people to eat a whole turkey. So. Don't hassle the Hoff. We're not talking about that Hoff. Keypole says, you guys are under siege. Yes, we are, from all the Central Americans and Mexicans coming across the border. We are very much under siege. And he says, didn't take my Dutch husband to go from freaking out the mention of a gun to carrying a couple himself. Based. Based. Porcelain says, enjoy your deconstructed sandwich tomorrow, Sean. Thank you. So, all right. Michelle said, I'm smoking a brisket. That sounds pretty good. J-Rock says, so a breast. I don't know. I'm not actually in charge of the logistics there. So I don't know. J-Rock, I'm eating tomorrow. That's my job. I'm not worried about anything else. So, all right, chat. So that's it for tonight. Like I said, Illinois, you kind of got a dub here, but you got a lot of problems that I don't like in this thing. This judge scares me. A lot of FUD lore here. So, with that said, guys, thank you all for being here. It is Thanksgiving officially. Happy Thanksgiving to everyone. I hope you guys have fun. It is Pilgrim D-Day. We will be live tomorrow. We will be live tonight at 9:30, hanging out. We got a lot to talk about, including stuff about P. Diddy. Actually, a lot of P. Diddy shit. It's fucking hilarious. So, yeah, chat. In the meantime, take care and happy Thanksgiving. Enjoy yourself with your family and friends. If not, we will be here. We'll hang out. And if you guys aren't with the family or friends, just, I guess I could say kind of stinks, but keep your head up, man, and we'll be hanging out tonight. So, Erday says, have fun, America. Thanks for Trump 47. Oh, all right. Well, good night, chat. You guys take care. I'll see you guys.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go, here on Sean Martin's Potentially Criminal Show.
Gobble, 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 gobble.